we placed a mention memo before a lordship yesterday. Can it be taken up sometime in the second week of November? We have
You have
taken
Mr.
HMO for the respondent.
Who applies for the appellant?
Appellant is the government. I took the consent.
You've taken consent?
Yes, yes. They signed it.
On request made by Chamal and the council for respond number.
Respondent number one, it's a big list, Miller. Respondent is petitioner.
Public writ petitioner. List the matter after?
So in the second week of November, sometime in the second week.
No, it's mentioned. 14.
May please note the final people listings of a retail appeal matter regarding admission to MBBS, my lord.
What is, I can't hear you.
My lord, praying for listings of a retail appeal, my lord, for admission of MBBS course, my lord, for tomorrow, my lord. Already he was appointed.
Monday.
May I please, Your Lordship. With regard to item number 3 of today's business, my lord, with all humility, my lord, I would like to submit Mr.
No mention memo.
No mention memo, my lord.
No.
There is a peculiar circumstance, my lord. My lord, Mr. Senior Advocate D.K. Mishra is appearing in this matter. Will not appear before Justice Karda Kite, my lord. He was his junior, my lord.
Okay.
I will inform all the respondents, my lord.
On request made on behalf of Mr. D.K. Mr. Leonard.
Anything.
List after?
Lordship, can it be after 3 weeks?
Or you can hear the matter. After 3 weeks.
Obliged.
With your lordship's permission, may I mention item 11? With the other side's consent, I'm requesting if it can be kept after the vacation.
You are for?
I'm for the appellant, your lordship.
It's on request made by Mr.
Abir Fukan, A. Fukan.
A. Fukan, Leonard, counsel for the appellant. List after use.
May I request if a specific date can be given?
My lord, there would be vacations. This matter would take some hearing. If my lord can have it on the 22nd of November. Last night I was also a discussion with him.
22nd level.
Obliged.
In this matter, I am appearing for department law. But instead of last 2 weeks, not can you take this in the first week of December? That will be.
It's up
Fine.
to you. It's up to
Fine, madam. Let it be on 5th, madam.
you.
5th.
December.
Much obliged.
Okay.
Motion.
Item 7 is with 8. Another.
Your lordship, this is a writ petition where we've challenged the constitutionality of a proviso in section 40, subsection 2A and 2B of the Wildlife Protection Act.
1 minute.
And I'll just briefly tell my lord what the issue is. Look, there is a regime envisaged under the Wildlife Protection Act, my lord, for animals which come under Schedule 1. Now, my lord, there's an exception carved out in the proviso which I just mentioned, my lord, for elephants. I'll take your lordship through certain provisions, but what I'm trying to sort of project in this writ petition, my lord, is that this exception which is carved out in the proviso has been extremely detrimental to the welfare of elephants, my lord. I'll show my lord how that has happened, but your lordship may kindly take up the Wildlife Protection Act for a moment first.
Yeah, we can have it together. Yes. Section 40.
Section 2, subsection 14. I'll show my lord certain provisions which will help your lordship understanding the
Section?
regime. Section 2, subsection 14, your lordship first, which defines hunting.
You got it.
Subsection 16. subsection 16 of section 2.
Yes.
Hunting within its grammatical variations and cognate expressions includes killing or poisoning of any wild animal or captive animal and every attempt to do so. Capturing, coursing, snaring, trapping, driving or baiting any wild or captive animal and every attempt to do so. Subsection B, which I just read, Milord, is relevant for the purpose of this writ petition. C, injuring or destroying or taking any part of the body or any such animal, or in the case of wild birds or reptiles, damaging the eggs and of such birds or reptiles, or disturbing the eggs or nests of such birds or reptiles. Now, your lordship may kindly come to section 39, which your lordship will find in chapter 5.
Yes.
My lord may just note the heading first. Trade or commerce in wild animals, animal articles and trophies. The section reads, my lord, every wild animal other than vermin which is hunted under section 11 or subsection 1 of section 29 or subsection 6 of section 35 or kept in bred in captivity or hunted in contravention of any provision of this act or any rule or order made thereunder or found dead or killed by mistake, and any animal, article, trophy or uncured trophy or meat derived from any wild animal referred to in clause A, in respect of which any offense against this act or any rule or order made thereunder has been committed, ivory imported into India and an article made from such ivory in respect of which any offense against this act or any rule or order made thereunder has been committed, vehicle, vessel, weapon, trap or tool that has been used for committing an offense and has been seized under the provisions of this act, shall be the property of the state government, and where such animal is hunted in a sanctuary or national park declared by the central government, such animal or any animal, article, trophy, uncured trophy or meat derived from such animal or any vehicle, vessel, weapon, trap or tool used in such hunting shall be the property of central government. Any person who obtains by any means the possession of the government property shall within 48 hours from obtaining such possession make a report as to the obtaining of such possession to the nearest police station or the authorized officer, and shall, if so required, hand over such property to the officer in charge of such police station or such authorized officer as the case may be. No person, subsection 3 is important, no person shall without the previous permission in writing of chief wildlife warden or the authorized officer acquire or keep in possession, custody or control or transfer to any person, whether by way of gift, sale or otherwise, or destroy or damage such government property. Now kindly turn over the page, Miller, at section 40. Declarations, Miller. I should have drawn your lordship's attention to actually section 9 first. I'm sorry, I'm taking your lordships back. Which comes under chapter 3, hunting of wild animals. Section 9 reads, Miller, prohibition of hunting. No person shall hunt any wild animal specified in schedule 1, 2, 3 and 4 except as provided under section 11 and section 12. Now, my lord, 11 and 12 deals with certain exceptions which may not be very relevant for the time being, my lord. Now, the schedule, my lord, schedule 1, I am concerned with schedule 1 to the act, which your lordship will find immediately after the act.
Yes.
Now, my lord will note serial number 12B, Indian elephant.
Yes.
So clearly, my lord, the highest protection is given, my lord, to all animals that come under schedule 1. That includes the Indian elephant, my lord. Now, kindly, my lord, may now come to section 40, which talks about declarations which are mandatory, my lord. Every person having at the commencement of this act the control, custody or possession of any captive animal specified in schedule 1 or part 2 of schedule 2, or animal, article, trophy or uncured trophy derived from such animal or salted or dried skins of such animal or the musk of a musk deer or the horn of a rhinoceros shall within 30 days from the commencement of this act declare to the Chief Wildlife Warden or the authorized officer the number and description of the animal or article of the foregoing description under his control, custody, or possession and the place where such animal or article is kept. Now, subsection 2, Millard. No person shall, after the commencement of this act, acquire, receive, keep in his control, custody, or possession, sell, offer for sale, or otherwise transfer or transport any animal specified in Schedule 1 or Part 2 of Schedule 2 of any uncured trophy or meat derived from such animal or the salted or dried skins of such animal or the musk of a musk deer or the horn of a rhinoceros except with the previous permission in writing of Chief Wildlife Warden or the authorized officer. That is after the commencement of this act, Millard. The permission of the Chief Wildlife Warden is a must before acquiring possession, custody, or control over any animal which comes under Schedule 1. Now, Millard, subsection 2A. No person other than a person having a certificate of ownership shall, after the commencement of the Wildlife Protection Amendment Act 2002, acquire, receive, keep in his control, custody, or possession any captive animal, animal article, trophy, or uncured trophy specified in Schedule 1 or Part 2 of Schedule 2, except by way of inheritance, Millard. Now, if your lordship sees this subsection 2A was inserted, Millard, by way of an amendment on 1st April 2003, the footnote 2, Millard, indicates that. And subsection 2A makes it clear, Millard, that after the commencement, no person shall acquire, control, custody, or possession of any captive animal that comes under Schedule 1 or Part 2 of Schedule 2, except by way of inheritance. So inheritance is the only mode, Millard. Then kindly see subsection 2B, Millard. Every person inheriting any captive animal, animal article, trophy, or uncured trophy under subsection 2A shall within 90 days of such inheritance make a declaration to the Chief Wildlife Warden or the authorized officer, and the provisions of subsection 41 and 42 shall apply as if the declaration had been made under subsection 1 of section 40. Now, here comes the proviso, Millard, which we are challenging, Millard. Provided that nothing in subsection 2A and 2B shall apply to live elephant.
Yes.
Then, Millard, subsection 3 may not be very relevant. Subsection 4, the state government may by notification require any person to declare to the Chief Wildlife Warden or authorized officer any animal or animal article or trophy other than a musk or musk deer or horn of a rhinoceros or salted or dry skins derived from an animal specified in Schedule 1 or Part 2 of Schedule 2 in his control, custody, or possession in such form, in such manner, and within this such time as may be prescribed. 40A. Immunity in certain cases. Now, there were cases, Millard, where declarations were not made in time. So therefore, there was an immunity provision under 40A. Notwithstanding anything contained in subsections 2 and 4 of section 40 of this act, the central government may by notification require any person to declare to the Chief Wildlife Warden or the authorized officer any captive animal, animal article, trophy, or uncured trophy derived from animals specified in Schedule 1 or Part 2 of Schedule 2 in his control, custody, or possession, in respect of which no declaration had been made under subsection 1 of subsection 4 of section 40, in such form, in such manner, and within such time as may be prescribed. Any action taken or purported to be taken for violation of section 40 of this act at any time before the commencement of Wildlife Protection Act shall not be proceeded with, and all proceedings, all pending proceedings shall stand abated. Any captive animal, animal article, trophy, or uncured trophy declared under subsection 1 shall be dealt with and in some manner and subject to such conditions as may be prescribed. Now, Millard may notice section 42 once. This is the provision before I go to the facts, Millard. Certificate of ownership. The Chief Wildlife Warden may, for the purposes of section 40, issue a certificate of ownership in such form as may be prescribed to any person who, in his opinion, is in lawful possession of any wild animal or any animal article, trophy, uncured trophy, and may, where possible,
mark in the prescribed manner such animal, article, trophy or uncured trophy for purposes of identification, provided that before issuing the certificate of ownership in respect of any captive animal, the chief wildlife warden shall ensure that the applicant has adequate facilities for housing, maintenance and upkeep of the animal. Now, Millard, the section 242, Millard, highlights two things: that before certificate of ownership is issued, the chief wildlife warden has to form an opinion that the animal in respect of which ownership certificate is being issued is in lawful possession of the wild animal or any animal. Second, Millard, the proviso makes it clear that the chief wildlife warden shall ensure that applicant has adequate facilities for housing, maintenance and upkeep of the animal. So these are the two things, Millard, that the chief wildlife warden has to ensure before issuing ownership certificate, Millard, under section 42. Now, Millard, why this proviso has been inserted under subsection 2A and 2B of section 40 is not at all clear, Millard. I have also annexed the Lok Sabha debate, Millard, pertaining to the 2003 amendment, Millard. Kindly have page 48, Millard.
I think we can issue notice at this stage.
My lord, I'm just praying for an interim relief.
No interim.
My lord, one aspect, my lord, I'll just have to take your lordship through certain ownership certificates that have been issued, my lord, by the state of Arunachal Pradesh, my lord. And I have, in fact, there's a finding, my lord, rendered by even this honorable court, my lord, where my, I think, learned friend had also appeared, my lord, which clearly renders findings that ownership certificates are issued, my lord, without any declaration, A. B, my lord, without verification of the lawful possession. C, without any verification, my lord, of the fact as to whether there are adequate facilities for the maintenance and upkeep of the elephants, my lord. What has happened is, my lord, ownership certificates are issued today within a matter of 1 week or maybe even 5 days thereafter, my lord, the elephants are transported. Huge number of elephants have been transported in this manner. This is encouraging illegal trade in elephants in many ways, my lord. But your lordship may note the finding which this honorable court has rendered, my lord, at page 107. This was an interesting case, my lord, where elephants were seized and the owner sought custody, my lord. And the custody was given by the revisional court. That was challenged by the state of Assam, my lord, and the revisional court's order was set aside. My lord, in this, the learned single judge was pleased to note the statements which were made by the owners, my lord. Kindly have page 107. And I have enclosed these ownership certificates also, my lord, with my petition. My lord, may have page 106, my lord. At the bottom, my lord, the section 40 is reflected, which I just read, my lord, pertaining to declarations. My lord, may see now page 107, para 24. Admittedly, father of accused, respondent number 1, so-and-so, died in 2006, but he has not made any declaration as per law. Further, the statement of accused bears much impact in as much as he said that he has no information of the religious institution to whom the elephants were being transported, nor he has contacted with Ravindra Kumar Singh to whom it was transported. He has submitted that as per communication with Barun Kumar Singh, he has applied for ownership certificate and transportation certificate, and the said Barun Kumar Singh procured all the documents for him, and Barun Kumar has also transferred an amount of 9 lakh for Lakshmi Prasad, it's one of the elephants, and rupees 17 lakh for Hari Prasad, 2 elephants, in his account by way of bank transfer. In the month of April, where Barun Kumar Singh approached the accused respondent number 1 in search of elephants and prepared documents on his behalf, and initially he deposited so-and-so. I'll skip the rest of it, my lord. Now, my lord, I may just point out some of the ownership certificates which, my lord, speaks volumes about the manner in which they are being issued, my lord, without any verification. Kindly have for a moment, my lord. page 82. Before that, I may just point out one aspect. I've just forgotten to show one very vital document, which your lordship will find at page 70. This was some information that was obtained from the central government, my lord, under RTI. It starts at page 71. Your lordship may straight away come to page 73. I don't want to detain much time, my lord. 73, your lordship will find details of captive elephant based on the information sent by states and union territories. My lord, has that table, my lord?
Yes.
My lord may come to serial number 29, which reflects the data pertaining to Arunachal Pradesh. Now, my lord will see about third column from the right that gives details of ownership certificate of elephants in private custody. My lord sees that on the very top, my lord. This is at the very top, the heading of the columns. My lord sees that.
Yes.
My lord may now come to the data relating to Arunachal Pradesh. It says 28. In other words, my lord, 28 ownership certificates have been issued by the state for elephants. Then my lord may come to the third column from the right, which reflects the figure 109. This is grand total captive elephants. So 109 captive elephants are there, out of which only 28 ownership certificates have been issued. Then just below the table, my lord, there are two footnotes which have been inserted in this information. The second point, my lord, Government of Arunachal Pradesh has 109 captive elephants. However, the detail of elephants has not been provided by the states. All other states have given this information. Arunachal Pradesh, your lordship will find all these spaces are left blank. They have no data. They have shared no data relating to how many elephants are in captivity, how many elephants. They have not given any kind of breakup. Now, my lord, the ownership certificates, which I was pointing out, my lord, your lordship will find ownership certificate of one elephant called Unni at page 82. I've given the typed copy, my lord, at page 82. Your lordship will find the true copy at page 85. My lord, here your lordship will find, this is dated 12th of February 2018. My lord has page 82.
Yes.
My lord, certificate of ownership, the second paragraph I am reading, certificate of ownership of the under-mentioned domestic elephant named Unni, as specified in the schedule below, is issued to Kuruvilla Cherian, son of so-and-so, the Arunachal Pradesh address, who has come into possession of this elephant by way of birth in captivity by mother elephant Lakshmi. Now, my lord, there is a guideline which is issued by the project division of the Ministry of Environment, my lord, which says that at the time of birth, my lord, there has to be a declaration made regarding the pregnancy of the mother elephant, my lord. Now, no such verification has been made. Page 57, if your lordship has for a moment, I have enclosed this guideline also, page 57.
Yes.
My lord, this starts at page 56. There are guidelines for care and management of captive elephants issued by the Ministry of Environment and Forest, dated 8th January 2008. My lord, I'll only refer to two paragraphs. Page 57, my lord, the second paragraph, illegal elephants, that is those which have not been declared under the declaration of the Wildlife Stock Rules 2003 or are found without valid documents, will be confiscated. It would be mandatory for the owners to declare in writing in advance to the nearest divisional forest officer or to the authorized officer by the state government of the pregnancy of the female elephant in order to get fresh ownership certificate of the calf. The certificate would be issued to the calves of the legal cows only after physically ascertaining that they are genuine offspring or after getting the DNA test done. No such verification has been done, my lord, in the case of Unni. Then your lordship may come to page 86, my lord. This is another elephant, which is actually Lakshmi, who is the mother of Unni, my lord. Now your lordship will see page 88 is the true copy. Now it gives the details of the elephant, my lord, the name, the registration, purchase from so and so in the first column, my lord. Again, in this case, my lord, there is no declaration under the wildlife stock rules, my lord. This is clearly liable to confiscation, my lord, which is provided for under the guidelines, my lord, which I just read at page 87. Then, my lord, the two elephants which are reflected in the judgment of this honorable court, Hari Prasad and Lucky Prasad, your lordship will find at page 89. Page 89, my lord. The true copy is at page 91. This is an ownership certificate dated 23rd of February 2018, my lord, in favor of an elephant named Hari Prasad. My lord will see in this, this is the same elephant, my lord, for which the owner had admitted that he had transferred. My lord, I read from the judgment of this honorable court that the elephant was transferred, my lord, after receiving an amount of 17 lakhs, my lord, which is clearly not permissible under the statute. Then your lordship will find the ownership certificate at page 94, your lordship. This is the other elephant which your lordship had noticed in the judgment of this honorable court. And this is an elephant named Lucky Prasad. Here also the owner had admitted that he had sold the elephant for rupees 9 lakhs. Just two more ownership certificates, my lord. At page 116,
Actually, we can issue notice of discussion. No,
well, one aspect which I was just pointing out, my lord, is that the elephants were transferred immediately after the ownership certificates were issued. This is what is very alarming, my lord. My lord, there are two. This just
Well, he has not challenged any of the ownership certificates, man. Transfer of any elephants, man, because then he has to make those affected persons as a party here, man. He has not preferred a PIL, man. It's a writ petition. So petitioner has to establish what legal injury he has sustained. It's not a PIL, man. It's a writ petition.
let me see my prayers for a moment.
Only because petitioner is confused why section 42 and 2B is not applicable to elephant. He is confused of that basically. He has filed his writ petition, my lord. It's a confusion, nothing else that I can clarify right now, my lord. If my lord produces the
Let me
wildlife
just-
protection.
1 minute.
May I just, my lord, show my prayers first, my lord.
No, I've seen your prayer.
My lord, I am asking for a declaration under prayer A, my lord, that the proviso to 42A and 42B inserted by so and so with effect from so and so is violative of Article 14 of the Constitution of India, read with Article 48A and 51AG, my lord. My lord, the second prayer for which I am praying for an interim, my lord, is prayer B. Restrain the
prayer, no,
respondent
it is
number
the act
3, my
of the
lord,
central
Arunachal
government, my lord.
Pradesh,
And
from
he should be
issuing-
given notice to the Attorney General, my lord.
1 minute, 1 minute.
restrain the respondent number 3 from issuing any fresh ownership certificate for elephants in the
I've
state of
seen
Assam.
your
Yes,
prayer.
my lord.
I've seen your prayer.
Well, Lord, this requires consideration and
That will
because your
consider
lordship
on the
definitely
next
have
agenda
have
point.
jurisdiction.
Yes. But Mr. Furqan, let me also. Issue notice. Who appears for union?
I have for respondent 2.
Have you served copy on the union?
Yes, my lord. Well, all that I'm praying for is without verification of lawful possession and without verification of the adequate facilities, ownership certificate should not be issued. This is what the law mandates, my lord. I'm not asking for anything beyond the law.
Who appears for the Union of India?
RKD Chaudhary, man.
Mr. RKD Chowdhury, Deputy Solicitor General of India. appears for respondent number 1. Assam,
I'm appearing from
Mr.
P.N. Goswami as
Yeah.
additional AG Malad. I'm appearing.
Ben Goswami, learner additional AG, appears for respondent number 2.
Two.
And Mr.
NNB Chaudhary,
NNB Chaudhary, learner
additionally.
additional advocate general appears for respondent number 2. So,
So person that-
extra copies,
It is the-
then respondents are allowed to file the contract. List the matter after 4 weeks. Preferential shall be considered on the next representation.
May I request if it can be listed before the green bench, my lord, on the 9th of November?
To see this is a follow.
Down one.
That will be decided by honorable chief.
May I request if it can be kept on 9th November, my lord?
That will be decided. Yes. The issue of maintainability raised by the learned counsel for the respondents is kept up.
Obliged.
Item 1 of daily list, admission.
This matter was to be admitted on the last date of hearing. And at that time, since my learned friend could not appear in the court, then we did not press for it. The matter has to be admitted.
You want to
As
go
far
for,
as far as the issue is concerned, it's a very limited issue. One single judge decides that the petitioners are not entitled to any relief because they are not covered by a 2015 notification, which applies only to casual employees and ad hoc employees, and specifically inhibits contingency employees from being covered. The counsel for the petitioners also considered to this fact, but still on humanitarian grounds, the learned judge said, you make one more representative. When the second representation was made, that was declined. So again, they filed another writ, which came before another single judge. The learned single judge can agree with the judgment passed by the earlier judge or can disagree. That's their discretion. But they cannot give a finding contrary to the judgment given by a learned single judge because it is a coordinated bench judgment. That is the legal issue involved in this case. So this requires consideration apart from the points on merit. Because the learned single judge at the second instance criticized the view of that notification, saying it is unconstitutional, though it is not challenged, we can still quash it, and also gave a further direction to the government that you regularize this person and give him pensionary benefits. You know, as far as the regularization is concerned, Uma Devi comes into the picture, where in para 53 or so, they say that even if it is an irregular appointment, it is okay. But if it's an illegal appointment, where the post is not sanctioned, scale is not sanctioned, you cannot do it. So this is the gist of the whole matter. If it is admitted, it can be heard anytime.
yes,
Lordship, I pray that this matter in the first writ petition, the Honorable Court has directed the petitioner to submit a representation.
no, that's what the Advocate General has already
Yes.
said now.
Yes, on
So-
humanity ground. Now, Lordship, what has happened is when this matter was from the Kohima outline bench.
Oh.
When the then CJ came down to the Kohima, he just directed the state respondent to bring instruction here before this honorable court, the petitioners approached this honorable court when there was 4 years time for their retirement. But due to pending this case, with due respect to the learned AG, this matter was taken up by the additional AG who is also present before this honorable court today.
That's a different, that's a different.
So what has happened is then CJ took up this matter to Guwahati, saying that he will dispose of. So he instructed the state government to bring instruction that forget about the regularization. And now
So we'll admit this writ petition and then we can go for a hearing.
I just humbly pray before this honorable court on my part, Lordship, since now the petitioners has already retired in 1921. I pray before this honorable court at the disposal of this honorable court, and just on humanity ground, all the other issues has been left out, except to kindly on humanity ground provide the pension benefit to the two petitioners. They were appointed on contingency in 1986 when the first DEO office was established at Zinheboto. They were the first peon and chowkidar to be appointed by the DEO office by the respondent.
That will be touching on the merits. And the issue or the direction on humanitarian grounds
Yes,
will not be permissible at this stage.
Lordship,
We can admit
since
this writ petition, writ appeal.
Please.
And fix a date for hearing, an early date we can give you.
Lordship, since I came all the way from Kohima, and it is my lord can see the records, it is the respondent government who has been taking time for the past 4 years, Lordship. So I thought that
Keep it
on
after,
my part,
after 3 weeks.
on my part, I have no submission. I just leave it at the disposal of this honorable court, and whether my lordship will just for the pension benefit only. They have retired in 2009. They approached this honorable court in 2017. So on my part, I wouldn't have any argument, lordship.
No, this writ petition, appeal is already admitted.
This is admitted.
Yes.
Well, I thought,
Lordship.
It was admitted on
Yes.
27/6/2023.
all right.
And since he's also here, I've been appearing on VC, but lordship, always the respondent government has been taking
Then
time.
if
That's
they
why I just,
Want to
came
hear
up.
it, I have no problem.
yes,
I
lordship,
have no problem.
lordship,
You want to go for a hearing
lordship,
today?
lordship.
There's no issue. Because you met your appearance only on 23/8, 23rd of August. That
Lordship.
was your first appearance.
23rd August. Through VC, lordship. This is the
Yeah.
first time I'm coming up before this honorable court.
So we can.
Please.
Yes, lordship.
Here the petitioners were appointed.
Let us first see the impugned judgment.
Please. Page 14.
14.
14. May I give a background of the judgment, then I'll refer to start. These petitioners were appointed in 1986. And their appointment letters are at page 52. 52. Contingent, temporary,
Do you have a typed copy?
I have that.
No, this is not readable, that's why I'm.
Unfortunately, your copy visible. This is more visible, even mine is worse. I'm sorry.
Yours is readable. Same thing, same thing. Same thing.
Continue.
Kichi, can you supply for type copies?
Your lordship.
Any other copies that are not readable?
We will file it. We type it.
Then we list it on a different date. Let him file.
Lordship, shall I supply after some time? We can let it be type out.
So the issue is that we have to go through the orders.
We'll file legible copies. Whatever is not legible, we'll place it on the copy.
Okay,
Sorry.
we'll give you a date. But Mr. Kian Gopal, Bal Gopal, Leonard, Advocate General Nagle. Also heard MS Z Zimomi, Leonard Counsel for the opposite party, for the opposite party, responder number 1 and 2, public writ petitioners. MS M Kichi, Leonard additional AG shall furnish readable copies, shall file readable copies of all the annexures of the annexures that are not readable within a period of 1 week, 2 weeks.
Yes, your lordship.
Within a period of 1 week from today. So, list the matter again on, when do you want? Give a-
Anytime in the last week
Sure.
of this month.
Short time.
This
lordship.
month, there'll be
Vacation.
vacation.
Okay.
Vacation is up to 3rd of November.
So before the 20th.
1st of November.
No, no,
3rd of
5th,
November.
up to 5th of November,
After that, before 10th
before 10.
or after 10th.
You give your convenient date.
Maybe 7th or 8th of November. it will
List
be
the
okay.
matter on 7th November. Is it all right? 7th of November?
Lordship.
Okay.
He's very angry with me from the morning.
If you have nothing to submit, you might appear through the BC.
Lordship, lordship.
You said.
I was appearing through VC, but on the VC always
But you said
Time-
you have nothing to submit.
yes, lordship. I just place at the disposal of this honorable court on humanity ground, that's all. I don't have to argue much. Obliged, lordship.
Two,
Yes.
Lordship, in this writ appeal, Lordship, which has, I was free for grievance, already admitted by the respondent, filed the affidavit in opposition, Lordship. And file on 8/9/23, Lordship, they have filed affidavit in opposition, Lordship.
Yes.
In para number 4, page 47.
Hmm.
May I read this, Lordship?
Yes.
That the deponent begs to state that after the passing of the judgment and order dated 28/1/16 by the coordinate bench of this honorable court in writ petition number such and such, all Assam English Medium School Association and others, the respondent corporation has agreed to adhere to the said judgment and order passed by this honorable court and has agreed that no recovery under the ESI Act from education institution and schools will be made respectively, that is from 28/1/16. And hence the respondent corporation undertakes not to make any recovery in accordance to the impugned notice dated 36/2015 from the writ appeal petitioner, which was as challenged.
The challenge was made with regard to the notification, Malad, dated 36/2015, which your lordship will find at page 25.
Page?
25 of the appeal.
Hmm.
And this notice was challenged, Malad, under 45A of the ESIC Act. If lordship may peruse the ESIC. Now, here, man, there's a similar writ petition, which is already read by the coordinate bench of this honorable court, that the challenge was before this court that the ESI Act shall not be applicable to education institution. However, this court, by judgment and order dated, my lord, 28/1/2006 has submitted that the ESI shall be applicable to the educational institution. However, my lord, if
One
you,
minute, one
my
minute.
lord.
Yes.
My lord, if your lordship may kindly turn to page 39 of the appeal, my lord. We have agreed to adhere to the judgment dated so and so by the 28/1/2006 and then by the coordinate bench of this honorable court. My lord.
Page,
My lord, it starts from page 32, my lord, the operative portion at page 39, my lord. Page 39 of the appeal. My lord, para 21, my lord. In this backdrop of the above reasoning, the extension of ESIC Act to cover the educational institutions to the impugn notification dated 6/1/2009 is found to be in order, and accordingly, the contention raised by the petitioners to the contrary are rejected. However, since the operation of the impugn notification was stayed by this honorable court, it should be applied prospectively to the educational institutions and no schools should be forced to subjugate themselves retrospectively under the ESIC Act. From 2006, the corporation has agreed that no recovery shall be made to the educational institution prior to 2016, my lord. So here, my lord, the notification which was under challenge was from the period 2011 to 2015. So hence, the corporation has decided that will not proceed with under further proceedings, my lord. However, my lord, liberty may be granted to assess fresh contribution of prospectively, that is after 2016. That is my submission, my lord. When your lordship may dispose of the appeal, my lord, in this manner, my lord, because we will not go for any recovery,
where's the statement again? Let us see the statement.
my lord.
There are four lots.
My lord, para 4,
Affidavit in opposition.
affidavit in opposition,
Page
para
number
4
46.
of my affidavit in opposition, my lord. May I read, my lord?
Yes.
The deponent begs to state that after the passing of the judgment and order dated 28/1/2016 by the coordinate bench of the honorable court in WPC number so and so, the respondent corporation has agreed to adhere to the said judgment and order passed by this honorable court and has agreed that no recovery under the ESIC Act from educational institutions and schools will be made retrospectively, that is from 28/1/2016. My lord, will not go for any recovery retrospectively, that is from 2016. However, my lord, in para 6, my lord, and page 48, we have also sought for liberty, that liberty shall be granted to the corporation to assess fresh contribution from the education institutions, that is also from the appellant after
Right.
2016, my lord.
Where is that?
My lord, at page 48, my lord. I'll read the page 47, my lord, para 6 of my affidavit in opposition. Has your lordship got me? May I read? The deponent begs to state that as per section 26B of the Employee State Insurance General Regulation 1950, every employer shall return of contribution in quadruplet in form 5, along with receipt copies of the challans for the amounts deposited in the banks to the appropriate office by the registered post or messenger, in respect of all employees for whom contributions were payable in contribution period, so as to reach that office within 21 days from the date of the permanent closure of the factory or establishment, as the case may be. Further, section 31 of the Employee State Insurance General Regulation 1950 provides that an employer who is liable to pay contributions in respect of any employee shall pay these contributions within 15 days of the last days of the calendar month in the month in which the contribution fall due, provided that where factory establishment is permanently closed, the employer shall pay contribution on the last day of its closure. However, the appellant petitioner has not paid any such contribution as per the act, or any intimation was provided to the respondent corporation about its closure. Hence, under the facts and circumstances, your lordship may grant liberty to respondent corporation to assess fresh ESI contribution from the appellant petitioner after 28/1/2016. That is my humble submission before the.
Yes, sir.
You are agreeable to this?
Lordship.
Who is the impugned judgment?
Impugned judgment, 41 page, Lordship.
Which,
Page 41.
41.
you agreed by? The fifth para.
Yes, Lordship, in 24,
Page 25,
25, Lordship,
the notification.
notification, Lordship.
No, you have filed this appeal against this judgment. is
Yes,
it?
Lordship, yes, Lordship.
By which para are you agree?
Lordship, in last para, Lordship, in para number,
Page 42.
page 43, para number 5, Lordship.
Which part?
Last part, you Lordship. Such a finding was rendered perhaps keeping in view the facts and circumstances of the case. However, in the fact of the present proceeding, the same cannot be made applicable as the school in question, that is the petitioner herein, has been closed since 1/4/2015, as per statement made in para 1 of the writ petition.
Yes. Okay. Heard,
P. Sharma, Lordship.
Mr. V. Shamal and counsel for the appellant. Also heard
M. Smith.
M.
Smith
M. Smith,
Only-
learned counsel,
for the corporation.
appearing for the
Respondents, all the
All the respondents.
all the
all the
responding corporation.
being aggrieved by the order dated 26/11/2021, passed by the learned single judge in WBC number 5822 of 2016. The present appeal has been filed by the appellants oblique. You were the writ petitioner. Darshit,
Yes, Lordship.
by the writ petitions. So, para. The relevant portion of the order dated 26/11/2021. Writs are under page 43, A to A. So, para. The respondent 1, 2, and 3 has filed an affidavit in opposition in the present writ appeal. And para 3,
Para 4, Lordship.
para 4 of the said affidavit in opposition, writs are under page 46, B to G. Para. It is the submission of the learned counsel for the respondents that the corporation undertakes not to make any recovery in accordance to the impute notice dated 30/6/2015 from the writ appellants oblique petitioner. However, they seek liberty to
Assess fresh contribution, my lord.
assess fresh ESI contribution from the appellant of the petitioner
Prospectively,
after 28/1/2016.
28/1/2016.
I prospectively from the passing of the judgment and order dated 28/1/2016 in WBC number 4121/2009 and batch of other informations. Stop. Para. After hearing the learned counsel for the submission made by the learned counsel for the respondents is accepted by the learned counsel appearing for the appellants. Stop. Para. In view of the concession made by the learned counsel for the respondents and on acceptance by the learned counsel for the appellant, this appeal is accordingly disposed of by permitting, by issuing, by directing that no recovery under the ESIC Act shall be made retrospectively with effect from
28/1/2016.
28/1/2016 from the
Appellant, my lord.
appellant society, correct?
My lord.
However, liberty is granted to the respondents to assess fresh ESI contribution
Contribution.
from the
Appellant.
appellant society after 28/1/2016. Stop. With the aforesaid directions, the impugned judgment dated 26/11/2021 passed in WBC number 5882/2016 stands modified. With appeal is accordingly disposed.
Item 4.
May it please your lordships. Well, today this matter is kept for the consideration of interim prayer. In the meantime, my lord, the government has filed their affidavit. Initially, I had challenged not initially, in the writ petition, I challenged the provisions of the act. But after the affidavit that has come from the government, my purpose seems served, and therefore, even without going for the purpose of interim prayer and even later on perhaps, that even without the challenge of the act, my interim prayer, so far as the private respondent number 6 is concerned, that can be considered as so far as the other party is concerned, I have the support of the government so far as the affidavit is concerned. Now, this matter, my lord, it relates to establishment and operation of cattle market. Now, under the Cattle Market Act 2021, only those who are registered cattle markets or if they have valid license under the Cattle Market Act, only they can operate the market. Now, earlier I wanted that either the provision should be read down or it should be set aside. Now, so far as the government affidavit that has come, they say that the act is valid. After all proper consideration at various levels, they came up with the amendments that was required. Now, sailing with the act, my lord, which I do not challenge at the moment, Section 10 of the Assam Cattle Preservation Act. Now, before I go ahead, my lord, so far as the private market is concerned, factually what is happening, they are neither the respondent number 6, they are neither a registered market, nor they have any valid license issued by the state authorities, who may be. On the basis of a NOC issued by the Deputy Commissioner of the district, they are running the market merrily under the nose of the authorities concerned. Here, I need to show before this honorable court whether the act says, even if you do not have a register, even if you are not registered, even if you do not have any license, whether on the basis of NOC you can run a cattle market. May I this? আমার সাথে কিছু করা আছে নাকি? At this stage, my lord, I will play only for stay
Are
of the
you
NOC.
challenging the act or not?
My lord, with the government affidavit, I need not challenge the act, my lord.
In that case, you have to file a writ petition.
Exactly.
If you are not challenging the provision, then you cannot lie.
My lord, I have not filed my reply. What I say, my lord, at the moment, as far as the government affidavit stands, I need not challenge the act. There may be reading out subject to if there is objection to the stay of the, if there is objection from the government for stay of the NOC on the basis of which the respondent number 6 is carrying the market without being registered or without, then I will pray for reading down the provisions. But if there is no objection from the government, my lord, then reading down the provisions also
Sorry,
not
madam,
required.
there is no ifs and buts. Either you have to challenge the provision of the act or you are not challenging.
My lord, for the purpose of interim prayer, I'm not asking stay. I keep the challenge in my writ petition, my lord. But what I say, for the purpose of the interim prayer, I need not argue against the provisions of the act. This is what I'm
No, are
saying.
you challenging the act or
The
not?
act remains under challenge, my lord.
Under challenge?
Yes. But for the purpose of the interim, I do not seek for stay of any of the provisions of the act. This I make myself clear, my lord.
I don't understand.
At the moment, I only seek, because initially when I came up with the writ petition before the government laid its stand, I had asked for stay of the
What is the
provisions.
stand of the government?
The stand of the government, my lord, says that the act and the provisions are valid, and the act amendment of the act was done for the purpose of preserving the cattle and for safety and protection of the cattle. My lord, this even I say. This even I say. The government affidavit, my lord, they say
Where?
in paragraph 3, my lord.
Hmm.
If I may please paragraph, it's a short affidavit in paragraph 3. That the deponent respectfully state by filing the instant writ petition, the petitioners have challenged the constitutional validity of the Assam Cattle Preservation Act on the ground that the various provisions of the Act of 2021 are inconsistent with Part 9 of the Constitution and violate several provisions of the Assam Panchayat Act. The deponent, while objecting the challenge made in the writ petition and denying the allegations to the effect that Act of 2021 is in violation of the provisions of Constitution in India and the Assam Panchayat Act 1994, respectfully states, my lord, this is what I want to say, that pursuant to an initiative taken by the government of Assam to examine the old acts rules in force in the state, the Director, Animal Husbandry and Veterinary Assam, by a letter dated 30th December 2020, forwarded a list of 1 service rule and 3 acts related to the department, stating inter alia that after perusal and analysis, if appears that the said acts require amendment, further it is stated that proposal for amendment of the 2 acts will be submitted separately along with justification and the draft cabinet memorandum. Therefore, the list includes the Assam Cattle Preservation Act 1950. Next para, my lord. In the meantime, the Commissioner Secretary, Government of Assam Home and Political Department constituted a drafting committee to draft a bill incorporating provisions to prevent slaughtering of cows and the protection of cattle in the state of Assam, consisting of the Principal Secretary, Home and Political Department as its chairman. The drafting committee held meeting on 8th of June 21. Thereafter, in continuation of its letter dated 30th December 2020, and with reference to the first meeting of the drafting committee, meeting held on 8 June 21, the Director, Animal Husbandry Veterinary Department, by letter dated 11 June 21, forwarded a draft amendment, that is the Assam Cattle Preservation Act 2021, prepared by the legal cell of the Directorate for Amendment of Cattle Preservation Act to the Additional Chief Secretary of the Department. In the aforesaid letter, 11 June 2021, it is stated that Assam was one of the pioneers state to legislate on the subject of preservation of cattle way back in the year 1950. However, the provisions of the act have not been implemented properly, and therefore cattle is continuously, my lord, I lay stress on this, and therefore cattle is continuously slaughtered illegally in Assam in violation of the act. In addition to the commission of crime of illegal slaughter of cattle in Assam, it is reported that millions of cattle are illegally transported from North India to Assam with an intention to smuggle it to neighboring country where animals are likely slaughtered. It is therefore an urgent necessity to amend the old act incorporating stringent provisions for penalty for illegal slaughter and illegal transportation of cattle so as to prevent illegal slaughter and cattle smuggling in the state of Assam. Accordingly, the director requested to take necessary steps for amendment of the Assam Cattle Preservation Act 1950 and make it more relevant in preventing illegal slaughter and illegal transportation of cattle. In para 5, my lord, I read it, my lord. Thereafter, the draft bill of the Preservation Act Bill 2021 to amend the Assam Cattle Preservation Act 1950 was prepared by the Home and Political Department and placed before the State Cabinet, and the same has been duly approved. Therefore, it is a need of the hour to enact a new legislation inserting provisions of prevention of uncontrolled slaughter, my lord, uncontrolled slaughter, consumption and transportation of cattle, inserting stringent provisions for punishment in cases of violation of the provisions of the Act. In furtherance with the above objective, the draft act has been prepared and the Home and Political Department has obtained the views concurrence of the other departments, and thereafter the Act of 2021 has been enacted and published. Now, my lord, if I may take this honorable court, but the rest, they are not debating what we are saying, nor am I to debate so far as they are saying, because so far as the NOC is concerned, they have come up with the 2021 Act. With what purpose? With the purpose to see that there is no uncontrolled, let me read from their language, that therefore cattle is continuously slaughtered illegally in Assam. And then they say that it is therefore an para 4, which I had already read, my lord, and it is therefore an urgent necessity to amend the old act, incorporating stringent provisions for penalty for illegal slaughter.
That has been done.
Yes, it has been done. Now what is happening? Exactly, I'm grateful, my lord. Respondent number 6. Now what? Respondent number 6, without, in consonance with the Act, in violations of the provisions of the Act, which the learned Advocate General is supporting his Act, of course. The respondent number 6, without registration and without valid license, on the basis of only an NOC issued by the Deputy Commissioner, is running a cattle market. Now, is that permitted, my lord? May I take my lord to the Act which the government is supporting? Section 10.
Which act?
Assam Cattle Preservation Act. No,
When is it going to-
animal market regulation. My lord, I think I can give my book also because I have quoted it under the Act. Can I just pass on my book at the other book also? I have it quoted. I'll read it from my petition. Animal
You are
market,
supporting this act, correct?
my lord, it is like this,
You
my
are
lord.
not challenging this act.
If this Act is correct and it is properly interpreted, then the NOC cannot stand. The Act, it is question. My prayer is twofold, my lord. Either the provisions be struck off or it may be read down. Now, if the provision is interpreted correctly, my lord, then struck off is not necessary. It may be read down. And now how it can be read down? I have placed the affidavit of the government and I'm placing the provision which allows regulation of cattle market. Now, if the affidavit of the government and the provisions are taken, struck down will not be necessary, reading down is maybe necessary. And therefore, I cannot say that I withdraw my prayer. Either struck down or reading down, either of the two is necessary. But now I see that after the affidavit is come, struck down may not be required, reading down will be required. Because reading down will be in consonance with the affidavit filed by the state government. And this is what we are wanting to say. And they have said so in their affidavit. Therefore, reading down is necessary.
Which is the provision?
Section 10
You've got a copy.
of the Assam Cattle Market Act, of the Assam Cattle Preservation Act. Every animal market of recognized, it has to be recognized. Every animal committee of recognized animal market shall issue proof of sale and purchase of animals in the prescribed format to the purchaser and maintain proper record for inspection by the competent authority. If any animal market fails to comply with the provisions of this section and rules prescribed in this regard, the license or registration of such animal market shall be cancelled, and the person responsible for such non-compliance shall be barred from entering the market and fined as may be prescribed, after providing the animal market committee or the person, as the case may be, an opportunity of being heard. Now, this section 10, what does it provide? It provides for a recognized animal market. Now, when respondent number 6 is not a recognized animal market, it is not registered, it does not have a valid license, whether on the basis of NOC, the respondent number 6 can operate a cattle market. That's the question that we need to answer at the moment. In my respectful submission,
So in other words, you are supporting this section 10, correct?
I'm supporting the subject section 10, provided, my lord, that not for purpose of strike, not for the purpose of striking down. I'm not supporting section 10 for the, but it is interpreted correctly, my lord. That is
Yes.
why I'm seeking for reading down. Reading down, my lord. My lord, my
This
challenge,
by a single bench.
my lord, the reading down cannot be before the single bench because I had filed the writ petition before the single bench, whereafter it has been sent to the division bench, my lord.
No,
But
that point
since-
of time, you say you have challenged the section
Yes.
10 and section 3A.
Yes,
So that's why it's before the division bench.
exactly.
If you are not challenging the.
I
provision,
challenge-
you are
I
challenging the
challenge the-
provision.
Yes, my lord. I'm
But
sorry.
the way you are submitting is that though this section 10 provides certain acts to be done, complied with, while allowing an animal market, but then this by notification, the respondent number 6 have been allowed to run the market without having a license and the registration.
My lord, my challenge, so far as my challenge is concerned, I'm not giving away the challenge, my lord. I'm not giving away the challenge. I also
You
say,
have to make your stand very clear.
and my stand is very clear, my
Either
lord.
you are challenging this.
I challenge, my
particular-
lord. I challenge. The provision is under challenge, my lord. That challenge, I'm not taking it off. I am saying today, it is not for final hearing. Today is for consideration of the interim prayer. Now, when at the time when my lords are considering the interim prayer, my lord will not stay the act. So for the purpose of interim prayer, I am saying that even if you go by the act on the basis of it, because I have other challenges also. That is why I cannot give away my challenge. But even if we keep, because normally the interpretation is always that unless I can really show that it is unconstitutional, this, my lord, until the hearing takes place, will take it to be constitutional. Normally that is the interpretation given.
No, see,
But what I am, sorry,
See, madam, you are challenging this act. Now you want an interim on the basis of this section. How can that be?
my lord, I don't want it on the basis of this section. I am just projecting that why an interim prayer should be
You are
granted.
saying
Wha-
the respondent, private respondent, is running the cattle market against section 10, correct?
Yes,
Which is not in consonance with section 10. And therefore an interim order has to be passed so that section 10 is implemented, correct? Other side, you say you're challenging.
I'm
the
not saying
violence
so.
of
No,
section
I'm
10.
not saying that section 10 has to be implemented or not, my lord. That we will see when we go for the final hearing. What I am saying, for the purpose of my interim prayer, whether the respondent number 6 can be permitted to run a market in violation of an act which is still surviving. Will the state government come and say, no, respondent number 6, even without being registered, even without
Is
a
it in
license, you
violation
can run
of
the
the-
market.
Is it in violation of the whole act or certain provisions of the act?
My lord, at the moment, it is section 10 of the act,
That is what we're saying.
section 10 of the act. These I am placing, I have other provisions also which I challenge, my lord, because we are an Anchalik Panchayat. Under the 73rd Amendment Act, Constitution Amendment, my lord, the Panchayat has been given a special place and a special importance that so far as Panchayat are concerned, they will be a self-government institution. And therefore, my challenge.
Yes, Advocate General, what is-
So it is a classic case, lordship. They want to have the cake and also eat it too. So they have to first clarify what exactly is their stand. If their stand, if the challenge is against the provisions of that, fine. If it's, we have already filed. She wanted to file the response. I have heard her that she have to give a reply. Let the reply be filed and the matter may be traced out at one go, lordship, without taking anything for the interim. The
That
case is
is-
otherwise ready.
That is so far as the provisions are concerned. I'm sorry.
No,
for
no,
mentioning
it cannot
that
be in
so far as
piecemeal
the provisions
basis
are concerned. So
because
far as- Sorry, I'm sorry.
it cannot go on piecemeal basis, lordship. They want the section 10 should be there and the provisions of the act should be strictly followed while issuing the certificate. The certificate has been issued in terms of the rules, which my learned friend has not uttered a single word regarding the rules. Whatever certificate has been issued, there is a clear provision how the certificate, who can apply, what is the procedure of issuing the certificate, and what is the format of certificate.
Would you like to file a reply to the affidavit in opposition?
My lord, today I'm here for the purpose of interim, my lord.
We are not granting you interim.
My lord, then let the interim be rejected. Because here
Okay.
my stand is very clear.
No, you have to make your stand very clear.
I am very
After that,
clear, my
we'll
lord.
Reject or will allow the interim.
My lord,
First thing is, are you challenging section 10?
my lord, yes, I am challenging.
Then how do we pass it interim? When you
I,
are challenging the violence of section 10?
my lord, now so I am saying,
Are we,
far as-
We have to get.
we say that you are challenging the violence of section 10.
my lord, in
And then
the,
on the other side, we
we
say
have to-
the respondent has to act in terms of section 10.
no, my lord. No, that is not my prayer and that is not my submission. What I am saying, either the stay of the provisions be considered, or if pending hearing, the stay of the provisions cannot be considered at this moment. I say, since the act without an interim prayer continues to hold the field, whether anyone, be it respondent number 6 or myself, any petitioner or any third party here, can it operate a market without the license of a provision which is not been stayed?
Same thing, same submission.
Yes, exactly, my lord, but it makes a difference. Let the Advocate General say yes or no to my answer without explanation.
On the
I will
basis
only
of
make
your
submission. I will not
submission
say yes
only,
or no.
we're asking you whether you are still challenging the.
Yes,
provisions
my
of
lord,
section-
yes, I challenge, my challenge continues, my lord. I'm clear about it, my lord. I'm clear about it, but whether the question still remains, my lord, unless the government is trying to defend respondent number 6, I do not know, unless the respondent number 6 says that on the basis of this, I'm operating my cattle market, that is why there should not be stay. So far as the certificate that my learned friend is issuing is saying, so far as the certificate is concerned, it's a no objection certificate. Whether there is any provision in the act which they can show that without being registered or without there being any license, whether on the basis of NOC issued by any authority or the deputy commissioner for that matter, whether we can run the cattle market. If it is so, there are too many bail petitions filed. Too many arrests are made because it is not without registration and without valid market. At least it will serve someone's purpose, my lord. Advocate General is making it clear that the NOC should not be stayed, because that means, because even without being registered and without a license, you can run cattle markets. If that we understand, then some people will not be arrested. Let this message go to the government and the citizens. I'm very clear about my stand, my lord. I'm not asking for stay of the act as of now. If the act is stayed, very well. But if this honorable court considers that we need a hearing before we stay a legislation, my lord, because when a legislation is passed, it is done with after a lot of exercise. It may be sustained finally, it may not be sustained finally. But we take it this way, that even if it is sustained, even then, whether the respondent number 6, without being registered and without having valid license, can it operate as cattle market? That's my simple.
What is the provision of requirement of license and the registration?
That my lord, since my acts are both, I passed on both my acts, my lord.
That is precisely the reason why we are asking madam again and again.
My lord,
You are relying on the provision of this section 10. At the same time, you are challenging it.
my lord, unless it is stayed, we all have to follow. Even if I am running a cattle market, I will have to go by the provisions, my lord, unless it is stayed. No citizen can come and say that because I don't like the act, I don't need to follow. It cannot be like that, my lord. My lords. Thank you. This, my lord, and even if I don't like a legislation, even if I challenge the act, unless this any court of law stays the provisions of the act, we have to follow, my lord. Even if I challenge, I cannot say I filed a writ petition, I will not follow your law. Can I say this like this? In my respectful submission, I do not have that authority. Nor that the respondent number 6 has the authority, and the respondent number 6 is quiet. Who is defending the respondent number 6? I'm not even challenging, not even taking a stand against the state government. Now, who is defending respondent number 6? Whether the respondent number 6 is at all defended, my lord. Because at the moment, the state government pouncing, my lord, there is no reason, my lord. My lord, if you go by
Where are the rules?
section,
Rules is a part of that yellow book. Otherwise, I have it. In that book also, lordship will find those at page number.
first the substantial provisions have to be followed with before we go to the rules also.
In the same book, in the later part. Page number.
Section.
Page 19 onwards, the rules.
Section 3A, my lord.
Page 19.
19, 18 onwards.
Who is the relevant portion?
Relevant portion, of- I have it. Application for certificate rule 4. Any person intending to slaughter or cause to be slaughtered or intending to offer or to cause to be offered for slaughter any animal as mentioned in schedule shall apply in Form A to the competent authority of the area in which bull or bullock is to be slaughtered for the issuance of a certificate, and the bull or bullock is fit for slaughter. So this is the procedure. Now the competent authority, rule 3, the district magistrate of the concerned district shall be the prescribed authority to exercise the power and functions under subsection 3, 4, and 5 of section 5 of the Act. So that notification also is a part of the pleadings. Page 30. In page 39 of the writ petition, lordship, the designated officers.
Page 39.
39. Notification dated 25th July 2022 in exercise of the power conferred under Section 21 of the Assam Cattle Preservation Act 2021, the Governor of Assam is hereby pleased to delegate the power function under the Act as below, with effect from the date of issue of this notification until further orders. Section 7, 8, 10, designated competent authorities, Director of Animal Husbandry, Section 8, District Magistrate, Section 10, District Magistrate, or his authorized representative. So, and the formats are also given, everything is done. If there is any flaw or any glitches in issuing of the notice, this license or the NOC, it is a matter before the learned single judge. And we are not defending anybody, we are defending the act and the rules. We do not know who are there also.
Now, my learned friend has already
And that,
placed.
the other side is putting words in my mouth that I am defending Respondent 6. No, I am defending the act. That is my role.
My learned friend has already placed the rules also. Is the delegated authorities, the district magistrate, no quarrel with that for the moment. But whether without being registered and without having a license, the form is also there, without having a license, does the Advocate General still say that one can operate the cattle market? In my respectful submission, under the Act or the rules, both does not permit without registration or without having license. In no circumstances you can operate the cattle market.
But who are they, the petitioners? That is the main question.
I'm
They are
the
Panchayat, and the
Panchayat.
Panchayat, their activities are governed by the Panchayat Act of 1994. How they want to transgress into the Act of Cattle Preservation? They have no role here. If something is in violation, it is the state government who will look into it. Panchayat is not given that role of supervising
The Assam
the
Panchayat.
various agencies or various stakeholders activities under the cattle preservation of. They are not the monitoring authority. Then we'll have to challenge their status, their locus standi. If they want to usurp the power of the other prescribed authorities.
Since my learned friend is bringing up that, my lord, I thought that since I'm not asking for stay, my lord, page 40 of my writ petition, my lord. What is my locus, my lord? Let me state, my lord. This is the 73rd amendment, my lord, of the Constitution, which gives me locus, my lord. I need not really answer the state also. Statement of objects and reasons. Though the Panchayat Raj institutions have been in existence for a long time, it has been observed that these institutions have not been able to acquire the status and dignity of viable and responsible people's bodies due to a number of reasons, including absence of regular elections, prolonged supersessions, insufficient representation of weaker sections like scheduled castes, scheduled tribes, and women, inadequate devolution of powers, and lack of financial resources. Devolution of powers, my lord, I lay stress on this. Inadequate devolution of powers and lack of financial resources. Article 40 of the Constitution, which enshrines one of the directive principles of state policy, lays down that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. In the light of the experience in the last 40 years, and in view of the shortcomings which have been observed, it is considered that there is an imperative need to enshrine in the Constitution certain basic and essential features of Panchayati Raj institutions to impart certainty, continuity, and strength to them. Accordingly, it is proposed to hold a new part. My lord, a new part came into the Constitution to empower us, to add a new part relating to panchayats in the Constitution to provide for, among other things, Gram Sabha in a village or group of villages. Constitution of panchayats at village and other levels. Direct elections to all seats in panchayats and at the village and intermediate level, if any, and to the officers or of chairpersons or panchayats at such levels. Reservation of seats for the scheduled caste and scheduled tribes in proportion to the population for membership of panchayats and office of the chairpersons in panchayats at each level. Reservation is of not less than 1/3 of the seats for women, fixing tenure of such and such. This I need to continue. fixing tenure of 5 years for panchayats and holding elections within a period of 6 months in the event of supersession of any panchayat, disqualification for membership of panchayats, devolution of the state legislature of powers, devolution, my lord, what it requires by the 17th Constitution Amendment, devolution of the state legislature of powers and responsibilities upon the panchayats with respect to the preparation of plans for economic developments and social justice and for the implementation of development schemes, sound finance of the panchayats by securing authorization from state legislatures for grants in aid to the panchayat from the consolidated fund of the state, as well as also assignment to or appropriation by the panchayats of the revenues of designated taxes, duties, tolls, and fees, setting up of finance commission within 1 year of the proposed amendment, and thereafter every 5 years to review the financial position of the panchayats, auditing of accounts, powers of state legislatures to make provisions with respect to elections to panchayat under the superintendent's direction and control of the chief electoral officer of the state, application of the provisions of the said part to union territories, excluding certain states and areas from the application of the provisions of the said part, continuance of existing laws and panchayats until 1 year from the commencement of the proposed amendment and barring interference by courts in electoral matters relating to panchayat. Now, this is important matter. The bill seeks to achieve the aforesaid objectives. This is the objectives, my lord. Even to see that state legislature is, my lord, denuded of certain powers, but the panchayat is empowered, my lord. The panchayat needs to be empowered, and that is why there are part 4 of the constitution has been carved and inserted to empower the panchayats, my lord. My friend asked, who am I? So I'm saying that I'm the Anchalik Panchayat. The Constitution 73rd Amendment 1992. Now, if we can take the Constitution, my lord, 243G, sorry.
Yes. Is it admitted?
243G of the Constitution, my lord. Power, authority, and responsibilities of panchayats. May I replace this, my lord? 243 capital G of the Constitution, my lord.
No, that's not.
Article. Powers, authority, and responsibility of panchayats.
This writ petition is before this court
My lord.
because you are challenging the virus of section 10 of the act
And other provisions, my lord.
and other provisions.
My lord.
Maybe.
Yes, and also,
So we are dwelling only on that issue.
my lord, there are 2 parts to it, my lord. One, I'm challenging the provisions of the act, and secondly, my lord, so far as the private respondent number 6 is concerned, without any authority of law on the
So now
basis
the
of a
issue-
NOC,
No, today, since the other side has filed the affidavit in opposition, you can take a decision whether you want to file your reply or not. If
Uh,
you don't want to file a reply, we'll admit this, list it for hearing on the virus of the provisions of the act,
my lord,
of the Cattle Act.
my lord.
That's all.
As so far as the interim period is concerned, if my lords are
That
not
can be
inclined,
that
not
can be-
inclined, let it be,
that
let
can
it be rejected, my lord.
That can be considered after you file your reply.
My lord, I go by the affidavit filed by the government for the purpose of my interim, my lord. That is what I was saying, my lord. For the purpose of interim, I stand by the affidavit filed by the government because they are supporting my stand here for the purpose of interim period on
What
affidavit.
is the government saying in the affidavit? You have
In
read
the
it. You have-
affidavit, my
you have
lord,
read
they
it.
say, in the affidavit, they say that the Amendment Act came into force to see that there is no illegal slaughter of market and there is no illegal markets. That is what they have very categorically stated in their affidavit. And going by this affidavit, my lord, I point out that respondent number 6, without having any license and without any registration, my lord, they are running a cattle market on the basis of the NOC. That is what I'm saying. Let my prayer be either consider, let my prayer be considered, let it be allowed or it is rejected, no problem, my lord. I'm coming with a prayer, my lords have the liberty to, my lord, either allow or reject it, but let it be considered, my lord. I stand here today for consideration of my interim prayer, not to argue on merits the whole case, my lord. It
No,
is,
that is the issue.
it is, my lord, it is,
If you want to go for your interim prayer,
my lord.
maybe you'll have to sacrifice some stand taken in your
But without
petition.
sacrifice, I plead for consideration my interim prayer. Let it be allowed or let it be rejected. Nothing, my lord. It's all right.
Your
Because
prayer-
I-
your interim
because-
prayer is neither capable of rejection or, I mean, allowed.
Let it be said so, my lord. Let it be
Because
said
reason
so.
is, you are praying, your prayer is, interim prayer is based on the provisions of the act which you have put to challenge.
My lord,
Then how can
there are two
they are
sides, my lord.
taken
We are in a writ petition, my lord. We have to,
your two sides stand is totally contradictory.
let it
It's
be said,
conflicting.
let it be said and let it be rejected, my lord. I have no, but I stand on my pleading for the interim prayer.
Can neither
The
be rejected
government-
or be allowed.
It has been taken time and again, they have been taking time.
Madam, you know, the interim prayer will be based on your main prayer. If your main prayer is
My lord.
in conflict with your interim prayer, how this?
It is not in
consider?
conflict, my lord. It is not in
I think
conflict in my
I
respectful
think it's a
submission.
wastage of time.
My lord, I'm sorry if I'm wasting this honorable court's precious time. I'm very, very sorry, my lord. I'm sorry about that. But,
That's what I'm saying.
but,
You are basing you are challenging provisions of the act.
okay.
At the same time, you are making a prayer that the interim prayer should be considered or accepted, I mean, allowed on the basis of the provisions of the act.
No, I do not say
This
so,
is
my lord.
totally
I am
contradictory.
saying, I maintain the challenge to the provisions of the act, and I am saying that since in the constitution, the panchayat and the Anchalik Panchayat, my lord, the panchayat is before this honorable court, and the panchayat has its authorities under the constitution itself. Now this private market is running without being registered with us, without taking any approval from us on the basis of an NOC issued by the deputy commissioner, which does not have strength of any law or the constitution, my
Are
lord.
you saying that the panchayat has been established, the local self-government
My lord,
is
yes.
to oppose the legislative competence of the legislature?
My lord, the constitution has said so, my lord. That's the purpose of
Is
the
it-
amendment.
is it-
My lord, I
that
read
is
it, my
said.
lord. I'll read it again, my lord. I'll read it again, my lord.
Panchayat has to oppose the competency of the legislature.
My lord, I'll say
I'm
that. my
saying the state of this legislature doesn't have the competency in enacting this law.
Not it has the power to enact this law, but it does not have the power to regulate the markets under the Panchayat Act. Because the panchayat is a self-government and the constitution has empowered the panchayats to self-governance.
So according to you, this section 10 or section 3 has been enacted without any legislative competence.
My lord,
Is
it
it
is
so?
my lord, it is like this, my lord. I do not say they do not have the legislative competence. They have the legislative competence, but it has to uphold for this part 3. The amendment of the 73rd Amendment of the Constitution of India. That is what I say, my lord. There cannot be any legislation. No legislature, either of the state government of Assam or other state, my lord, is empowered to have any legislation which violates the provisions of the constitution.
That's why we're asking.
My lord, when in the state government there is a
Are
panchayat
these
government,
provisions are challenged on the basis of legislative incompetence? Competency of the legislature are
My-
challenging.
yes, my lord, I do that.
But
I do that. I
pleading-
do that because it does not have.
Leading doesn't say so.
Enough.
Yes, my lord.
Yes, you want to file your reply or not? If you want to file your reply,
I
we'll
did
see your
not want-
reply and consider the interim on the next.
I
day.
will reply, my lord. So far as interim prayer is concerned, it may be considered on the pleadings that is before
We'll
this honorable
consider
court.
your interim prayer after you file your reply. That's what we are saying.
My lord, I
we'll
pray
give
for
you-
consideration today. Let it be rejected,
We'll
my lord.
give you a fixed date.
Let it be rejected.
Well, I am the opinion of the peace. We have filed our affidavit in opposition to which reply has not been. Not been filed. My lord, my contention would be otherwise, that he does not have the local standing.
Whatever it is, you want to file your reply, we'll give you reply, we'll
I'll
give you.
file my reply, my lord. Of course, I will file my reply. I don't say that I will not file my reply.
To which affidavit do you want to file your reply?
I will file my reply to both the affidavits, my lord. One is supporting me. I will go by what the government has said. I'll file my reply.
MS,
But
yes,
so far as
well.
prayer is concerned,
you need counsel for the petition.
I plead that it may be considered, my lord. Otherwise, I am not wasting time. The other side people, they wasted so much time since the filing of the petition and
That's
since
why.
notices
How
were
much
issued,
time
my
do you
lord.
require?
I'll file it, my lord, within this phase, within this days only. Let it be fixed on 16th.
Praise for which time?
16th, my lord, let
File
it be.
reply to the counter affidavit filed by the state.
Ma, I'm not
Congress.
seeking time, my lord. I'll file it. Let it be fixed on
That's what
16th,
I'm
my lord.
saying.
Let it be fixed on 16th. If I desire, I'll file my reply, my lord. And so far as the interim prayer is concerned, let it be fixed on 16th.
16th, I have some
Let it be
difficulty.
on 17th.
Could it be on 13th, Lordship?
Friend that your friend wanted to an adjourn
Kindly address the court. Kindly address the court.
there till 15th, my lord, just for the purpose of date.
13th,
After 15th, any
after
date.
15th, then 23rd, Lordship.
23rd is a holiday.
24th.
24th is also a holiday.
also-
After the-
Oh, sorry.
20th it is a holiday. Any day before
Because
19th.
from 17 onwards, Lordship, there's a constitutional matter, bench matter of the state government in Supreme Court. So from 16th, I will have to be in Delhi. That's
Then we'll have to-
Citizenship Act and
Just say, I will also go travel with him to Delhi, my lord. Let it be either allowed or let it be rejected.
Then let it be after the summer vacation.
after the Puja vacation. Puja vacation.
Press my interim, my lord. I press my interim. Let not an illegal market continue. I'm sure the state government also does not want an illegal
My
market.
brother has
continue.
already told you
My lord.
that this is not a fit case, either to
Let
consider or
it be rejected.
to
Let it
reject.
be petition also.
Either to reject.
Please, my lord.
If you want to have a hearing of the whole writ petition, we are ready to hear it.
I'm ready, my lord. I'm ready. Even on the basis of the affidavit, without filing my affidavit also, I have a good stand, my lord.
Are you ready?
Let her start. I can give the reply tomorrow. My reply can be reserved for tomorrow at 10:30. I will give the reply.
It's up to you.
My lord, I'm ready for both. I'm ready for rejection. I'm ready for allowing. Let it not be tomorrow. Let it happen today. That is what I'm saying. Or since my friend says he has difficulty, let it be before
No,
the
it is not
vacation.
difficulty.
If it- No, you have said you were traveling. From 16th, you are traveling.
The case is to be heard today.
Yes. And my friend said that it's a classic case. I say it's a class, sorry.
Right in the chamber. Yes.
I say that my friend said it's a classic case. I say it's a classic case for the reason that the government affidavit is supporting me. I'm going by the affidavit, even there is objection, my lord. For what reason, I do not know. That is what. My lord wants to hear the whole petition?
Yes, we'll hear
My lord,
on the ground, only under one condition.
my lord.
That this writ petition is here because the virus of provisions of the Cattle Act is under challenge.
Yes, yes,
So you'll have to challenge those acts,
Yes.
those provisions.
yes.
You'll not go according to the affidavit filed by the government.
My lord, let them, if this honorable court wants to ignore the affidavit, I do not know, my lord. I will go by the affidavit which supports me, my lord. The state is giving an affidavit in my support, my lord.
So earlier you said that since the state is supporting your case, you're not challenging the virus of the act.
I did not say like that, my lord. I said for the purpose of interim, I
Let
need
us
not,
be very clear on this issue.
I am clear, my lord. I do
If
not know.
you're not challenging the virus
I am
of
challenging the
the
virus.
provisions of this act, this
I'm
will have to
challenging.
go to the single bench.
I am challenging the virus and I'm also taking support of the affidavit filed by the government. I'm doing both. Because the government's affidavit is supporting what I want to say. And why should I not take support of the
What is the
government?
ground?
My lord?
Challenge the provisions of the law.
That's
What is the ground?
73rd amendment.
Not only that, what is the law?
My lord?
Challenging the virus of the rules or the act?
Yes, my lord. That I will place.
There are two grounds only.
Hmm.
What are the grounds?
Unconstitutional, my lord.
Then next,
And I need only this, my lord. That is unconstitutional. I just place 73rd amendment and the
so
and the
according-
legislation,
according to it's inconsistent.
my lord. Because it denudes the panchayats of its powers, my lord. And the basic structure of self-governance given to the panchayats is then eroded. That is my challenge, my lord.
If you want to proceed, proceed.
Yes, I will proceed, my.
I have a preliminary objection. I am appealing for a The benefit of the act is not liable to be adjudicated by your lordship at this stage, because the fact stated in the writ petition is such that it is against the responsibility which can go to single bench. It is an academic exercise only to see the validity of the act, to adjudicate upon the validity of the act. I can say so.
You have raised the issue of maintainability.
Yes,
But my submission would be Lordship may take the issue of the validity of the act here. And if suppose it is upheld, Lordship may remand the matter regarding the factual disputes
yes.
to the learned single judge.
There is no factual dispute. It's all legal dispute. No factual dispute. Otherwise, without the reply, I cannot argue.
There's
There's
too
no
much of
factual dispute here.
presupposing,
There is
too
no
much of
factual
reason that the
dispute here.
government is supporting. Government is supporting both the acts, the Panchayat Act as well as the Cattle Preservation Act.
I have no issues. And the private respondent, they have not taken the plea of maintainability. In fact, they are taking, relying upon a judgment passed by the division bench in 2009. And that is a whole basis, that on the basis of the judgment and law laid down by the division bench in 2009 judgment, that is their stand, my lord. And I have no difficulty with the 2009 judgment also. Now, my lord, if we just have to part 9 of the Constitution, my lord, starting from Article 243.
So Lordship is starting the hearing.
Yes.
So my colleague will be here, Lordship. So I'll give my reply tomorrow.
My lord, the piecemeal, my lord said piecemeal will not do. And this piecemeal is both for me and for the other side also.
So both sides can complete their argument. My response, because I have to.
The idea is that you proceed with your arguments
Correct.
and then the learned AG will make his submission tomorrow.
That piecemeal I will not do because I'm not available tomorrow.
Okay.
I'm not available tomorrow, my lord. Let
This
it.
matter on. When do you want?
My lord, let my prayer be just noted down that I have prayed for the
No, no.
interim and
When do you
whatever.
want?
Whenever
15?
I'm not.
When are you
16th,
available?
16th, my lord. Up to
16,
15th, I'm not
learned
available.
AG is
Let it be
Not
on 12th,
available.
Lordship.
My lord, up to 15th from tomorrow, I'm not available.
Then after
16th,
vacation,
it has difficulty.
then let it come tomorrow.
I'm
Tomorrow,
not available.
Monday,
From today, I'm not
Monday.
available.
From today, you are not available.
I'm not available up to 15th. And then after my friend has
6th
problem.
November.
6th, no, highly obliged, Lordship.
6th. My lord has given 6th of November.
Yes. Whatever, 7th.
My lord, I'll just
You
check.
can
the-
just check your diary.
Never mind, we'll have the cake and eat it too, or let it be on 6th because 17th, again, I'm not available. 6th, my lord. On reopening, we'll have eat the cake, my lord, all of us. Let it be on
So let
6th.
it be on 6th.
And so far as my interim prayer is concerned, my lord is not taking note of my.
Not.
In that case, I really wasted time. I'm really sorry, my lord.
Doesn't matter.
I'm grateful, my lord.
Five, order.
May I please your lordship? Lordship, this PL Sumoto is regarding lordship illegal demolition of house in Botatoa lordship by the police personnel. On the last occasion, lordship, the respondent has filed the affidavit lordship.
Respondents have filed the affidavit.
Yes, lordship.
You like to file a reply?
No, lordship, this is Sumoto PL lordship.
Well, the commission was appointed earlier, but that particular commission was extended from time to time, but they ultimately the person who was appointed, he got retired. But he did not submitted the report. Now another committee has been constituted, my lord. That committee has asked for time till 31st of October, my lord, 30th of October, my lord. Lordship may take up the matter of reopening, my lord. I'll come up with the up-to-date position on.
Okay, on
on
request
resume.
made by Mr. D Nath, then Senior Governor Advocate. List down
7th or 8th November, my lord.
8.
8th November, lordship.
Deeply obliged.
Of the.
17 of supplementary list, order.
May please your lordship. My lord, the engaged counsel is in Lex, my lord. I may have paid the matter may be taken up after some time or at 2 p.m. my lord.
What is this IA about?
My lord, the IAC file was seeking leave, my lord. Here the applicant was not a party in the writ petition, my lord. My lord, obliged. Good.
Item 6 of daily list, hearing.
Sir. Look, capitation there. Code of BMN.
Wait, please, allow. What had happened? A particular gas agency was given to the petitioner by the oil company man. Now that was put to challenge by, though it was registered as a writ petition, but it was more in the form of a PN. Basically, issue was, my lord, the petitioner's perspective before the learned single judge was that this particular retail outlet is supposed to be set up in X locality. Now, my lord, the perception was, since it was set up in X, but in a distance from that place. So therefore, according to them, it was wrong. But my lord, as per the oil company's guidelines, my lord, that can be set up within 15 kilometers. And my lord, all these aspects are overlooked by the learned single judge. That's why we are before our lordships. Now, my lord, during the pendency of the writ appeal, my lord, there is an agreement between the parties. The writ petitioner would not like to press the writ petition. Therefore, the writ appeal can be closed in terms of the, my lord, agreement. And my lord, the learned single judge order will merge with the agreement. This is the copy of the agreement, my lord. I think my learned friend appears for the other side. One more. I can't do na. I'm sorry, man. One more. Yeah.
Which part of the agreement?
Yes, my lord. If your lordship will kindly come to page 2, whereas the first party was the petitioner in WPC number so and so, which was disposed of by order dated so and so in favor of the first party by the Honorable High Court. Thereafter, second party preferred writ appeal before this Honorable Court, which is pending disposal. Whereas first party at present do not have any grievance against second party and is desirous to continue, not desirous to continue with the litigation
against the second party, and as such, first party has decided not to pursue their prayer made in the writ petition, which was allowed by the Honorable Single Judge, and is agreed on the following terms and conditions. The first party shall instruct their lawyer to submit before the Honorable High Court that they do not have any grievance against the second party and is not desirous to continue the litigation against the second party, and they have no objection if the writ appeal pending before the High Court is allowed in favor of the second party. Well, in terms of the agreement, writ appeal can be closed, and the order of the learned single judge will merge with this order lordship will pass today. That's all.
Okay, heard Mr. Kiran Chaudhary, learned senior counsel, assisted by Mr.
And Gautam.
N. Gautam, learned counsel for the appellants. Also heard Mr. N.G. Khatania, learned.
He appears for the writ petitioner respondent.
1, 2, 4, and 6, my lord.
1 minute. That is standing counsel or the
No, my lord.
No, this is for the writ
Writ
petitioner.
petitioner.
He was the writ petitioner before the single judge.
writ petition respond number?
Here, my lord, 1, 2, 3, 4, and 6, my lord. 5, my lord, in the meantime expired.
For the respondents, 1, 2, 3, 4, and 6. And Oil India,
All India, my lord.
Well, they are permitting as we are operating, my lord.
stop. It is submitted that during the pendency of this writ appeal, the parties have entered in an agreement. Where is it taken? Whereby it is whereby the respondents 1, 2, 3, and 4. 1, 2, 3,
4,
4, and
6.
6 has agreed. No. Has come to an agreement that the respondents 1, 2, 3, 4, and 6 has no grievance against the appellants and has decided not to pursue the prayer made in the writ petition, namely WBC number
1 second, my lord.
5,111.
5,111 of 2012.
The agreement dated 10th of August 2023 is placed on the court. Is placed before this court and the same reads as under. You just get this whole agreement typed out stuff. In view of the agreement pass, in view of the aforesaid memorandum of understanding made between the parties. This writ appeal is accordingly closed by merging the
Order of the learned single judge in
merging
lordship.
the order of the learned single judge with the agreement made by the parties.
Diplom.
Obliged.
Nine.
May I please, Lordship?
Yes,
Lordship, kindly adjourn the matter for the day, Lordship.
why?
Lordship, Mr. R.K. Chaudhary is in Lex, Lordship, in court number 3, Lordship.
On request made on behalf of Mr. R.K.D. Chaudhary, Learned Deputy Solicitor General of India, brings the matter after 1 week.
Ten.
Lordship, may pass over the matter for the time being. My senior is on legs in another court.
Who's your senior?
Mr. P. Bora.
Yes,
I am for the respond number 1 and 2 in this matter, the writ petitioner.
okay, after some time.
Obliged.
Twelve.
Who's the respondent?
I am appearing for respondent number 5.
Oh, the headed is absent. Main respondent is absent.
Keveder.
Yeah.
Who's the Keveder?
Pallav Bhaumik.
Respondent number 1.
Respondent number one.
Bhumik is appeared for in the writ proceeding, he was
Personally appearing.
You're a Keveder.
Yeah, I am the respondent number 1. The order of the learned single judge is in my favor.
Are you ready?
Yes.
May I please? This writ appeal is filed against order dated 30/9/2022. Before I read the judgment, certain dates are very much relevant. May I read?
Give the list of dates. Yes.
Lordship, on 18/10/2021, the respondent number 1 has downloaded app on the advice of respondent number 4. And soon after downloading the app, an amount of rupees 94,604 was transferred from his account. The amount was transferred rupees 64,017 through UPI transaction. I want to clarify one thing. This UPI transaction through Google Pay is a third-party app and bank has no control over it. And when a person download this Google app, they have to admit the terms and conditions of the app. These are the terms and conditions. The heading, the documents prescribed terms and conditions which shall be applicable to all transactions initiated by user through Bharat interface for money application, BHIM app or the app developed by National Payment Corporation of India and using Unified Payment Interface UPI services as a mode for transfer of funds. The user is advised to carefully read and understand these terms and conditions before using the BHIM app. By using BHIM app, the user will be deemed to have read and understand and accepted the terms and conditions mentioned therein below and will be bound by these terms and conditions as amended from time to time as displayed on NPCI's website and BHIM app. And these terms will continue to apply every time the user use the BHIM app. Now your lordship will come. Page 4, clause 3.6. Clause 3.6.
Disclaimer of warranty. The Bhim app is provided on an as-is basis with no representation, guarantee, or warranty of any kind, either express or implied, as to its functionality. Downloading or using the app does not automatically entitle the user to receive hard copy of documentation, technical support, telephone assistance, or updates to the app from NPCI. No warranty is provided that the app will be free from defects or virus, or that operation of the app will be uninterrupted. Use of the app by the user is at the user's own discretion, and risk over the user is responsible for any damage resulting from the use of the app. So there is no warranty. If one uses the Google app, if he suffers any loss, it is his own responsibility. Then your lordship will come to clause 6.2. At page 6, disclaimer of liability. NPI shall not be liable for any loss, claim, or damages. 6.2, my lord, page 7. NPI shall not be liable for any loss, claim, or damages suffered by the user and or any other third party arising out of or resulting from the failure of any transaction initiated by Bhim app on account of timeout transactions, that is, where no reference is received from the NPCI or the beneficiary bank to the transaction required. NPCI or the beneficiary bank shall also not be liable for any loss damages. For use of this app, a personal identification number is given to the user, and it is only known to the user. No one can know unless he shared it with a third party. That is called MPIN, Mobile Personal Identification Number. In the present case, after downloading the app, the amount of rupees 64,017 was transferred through Google app. It is an admitted fact. So bank cannot be held liable for this transaction. Next, your lordship, another amount of rupees 15,093 was transferred through PG, that means payment gateway. And that payment gateway cannot be successful without sharing of OTP sent by the bank in the personal mobile number, registered mobile number of the user. Here your lordship will find for the second, the payment made through the debit card at page 108. 104, my lord. 107 is 105 is not legible.
One zero.
104. This is the type copy. The log is at 105. Since it is very small, I have typed it. When the amount was given, OTP for online purchase of rupees 15,093 at recharge payment through State Bank of debit card. Don't share this with anyone. And this OTP was sent on personal mobile of the user. That is the respondent number 1. And as per RBI guidelines, a transaction cannot be successful without sharing of OTP. So by sharing the OTP, the amount was transferred to the account of this respondent number 4, who is claimed to be a fraudster. Thereafter, this fraud happened on 18/10/2021. Immediately after, the petitioner lodged complaint with the bank. Bank, after receiving complaint, stopped the debit card. It is an admitted fact. There is no denial. Debit card was not stopped. FIR was filed before the police station. Complaint was also lodged before the cyber cell, and all those things are done by the petitioner. And on the very next day, complaint was, that is on 19/10/2021, complaint was lodged before the branch manager, State Bank of India, that is the appellant here. Since FIR was already lodged before the police station and card was blocked by the bank has not taken any action. And to this effect, your lordship will see the response of the beneficiary bank, that is the Federal Bank. This is the type copy is at page 106 of the writ petition. Made it. So when the petitioner lodged complaint before the banking ombudsman, the banking ombudsman asked the beneficiary bank, that is the Federal Bank, to give their response, and the Federal Bank has given response. This is at page 106. Regarding BO complaint number so and so lodged by Shri Pallab Bhaumik, we would like to inform as follows. Shri Pallab Bhaumik is not banking with us. He is maintaining accounts with State Bank of India, and he is making complaint against his bank. In the complaint, he is informed that some person portraying himself as customer care executive of Louis Philippe contacted him and asked to download some app, and accordingly the complainant acted, and he had lost a total sum of rupees 94,204. In 3 transactions, he had lodged a police complaint and also to cyber crime cell. He is requesting to retrieve the amount from the beneficiary account. Based upon the complaint, we have taken up the matter with our support team. It is noted that one UPI transaction of rupees 64,107 initiated from the account of Shri Pallab Bhaumik with SBI on 18/10/2021 was credited to Neo Banking Jupiter's saving bank account bearing number so and so. The name of Shri Pushpender Kumar with our bank. Pushpender Kumar is the respondent number 4 here. He is the fraudster. The beneficiary customer had transferred the above amount to other bank account via UPI transaction, and as of now, no balance is outstanding in the beneficiary account. We are attaching the copy of the statement of beneficiary SB account since opening the account as Annexure 1 for reference. we have not received any chargeback request against the above mentioned transactions from the remitted banks SBI through NPCI mail. We would take to submit that the amount transferred through UPI transaction by the complainant is of high security nature. The transaction could not be completed only by entering the valid UPI credentials, and the credentials are confidential and known only to the account holder. This statement is the beneficiary by the neutral party here. Amount cannot be transferred without sharing of MPI. In the instant case, the case as informed by the complainant through the complainant had acted according to the discretion or direction of the unknown person. The banks, regulators, etc. are cautioning all customers through several platforms not to share any of the credentials of their accounts to anybody, and requesting not to click on any link, QR code, etc. Despite all these, the customers are doing all sorts of things and afterward making complaint. Hence, the loss occurred to the complainant due to his gross negligence only. This is the statement of beneficiary bank. I am quoting this only because in the judgment, learned single judge has stated that there is no response from the beneficiary bank. It is in the judgment. But the response of the beneficiary bank is on the record, and this is filed by the petitioner himself in the writ petition. Next, your lordship will see Annexure 6, page 83. Second paragraph. Yes, madam. Second paragraph. This is the email given by the Louis Philippe. It says that it appears some financial data pertaining to transactions between 23rd June 2021 to 1st December 2021 may have been hacked. Since our record shows that you have made transactions during this period, we request you to take necessary measures to secure your credit card. This mail is given by Louis Philippe, respondent number 3, to the petitioner. So, in fact, any loss is suffered by the petitioner, it should be claimed either against respondent number 3 and the fraudster who is already identified by the police. It is on the record. Admitted, fraudster has been identified, and the respondent number 3 itself is admitted that data was hacked, and bank has shared the OTP, and this was shared by the petitioner. So bank is not liable. And on this finding, the London Ombudsman has given its finding. That is it. That is annexure 10, page 116. The relevant finding is page 119. Para 2. The bank has submitted their version dated 24/2/2022 stating the complaint pertains to the unauthorized transactions of rupees 94,204 done on 18/10/2021. The amount of rupees 64,017 was withdrawn via UPI and transferred to Federal Bank beneficiary attached. Amount of rupees 30,186.80 paisa was withdrawn via PG transaction. OTP logs are attached for the PG transactions. The UPI transaction cannot be executed without the registered mobile number and secret MPIN. The PG transaction cannot be executed without the card details and validation of OTP. We have to submit that the transactions were executed due to the customer's negligence. It is the finding of the ombudsman. Transaction occurred due to the negligence of the complainant, that is the petitioner. As per circular number so and so dated July 6, 2017, section 7(1), in cases where the loss to the customer is due to negligence by the customer, such as where he has shared the payment credentials, the customer will bear the entire loss until he reports the unauthorized transaction to the bank. RBI guidelines is also on the record here, looks. So it was the finding of the Reserve Bank of India that if the petitioner, if the complaining person suffered any loss due to sharing of payment credential, he has to bear himself. Bank would not be liable to compensate him. This is the guidelines of the Reserve Bank of India, and that guidelines is here. Annexure 5, Your Lordship. It starts from page 74. Relevant page is page 76. Reserve Bank of India circular. Liability, limited liability of a customer. A customer shall be liable for the loss occurring due to unauthorized transactions in the following cases. 1. In cases where the loss is due to negligence by a customer, such as where he has shared the payment credentials, the customer will bear the entire loss until he reports the unauthorized transaction to the bank. Any loss occurring after the reporting of the unauthorized transaction shall be borne by the bank. So, after reporting, had there been any transaction or withdrawal from his account, the bank had to suffer. But before that, bank is not liable. Admittedly, after reporting to the bank, the debit card was blocked. So there is no suffering. of the petitioner. So on this, against the order of ombudsman, the writ petition was filed. And relevant paragraph in the judgment is paragraph 22, Your Lordship.
What is the judgment?
Paragraph 22, page 137 of the appeal. These were the factual metrics, Your Lordship. Paragraph 22, page 137.
Yes.
Yes, my lord. From the pleadings available on record, it is evident that the 3 online transactions from the petitioner's account took place on 18/10/2021, when he had downloaded the mobile app on being prompted by the fraudster. The petitioner had done so in order to get refund of his money. Louis Philippe, the aforesaid 3 transactions were evidently unauthorized, as the petitioner never intended to transfer any amount to the respondent number 4 by downloading the mobile app. The respondent number 2 has also not denied. Respondent number 2 in the writ petition was the State Bank of India, that the transaction was unauthorized. Therefore, merely because the petitioner had downloaded the mobile app, that cannot be itself led to the presumption of negligence on the part of the petitioner in assisting the unauthorized transactions. I dispute this finding, because when one person downloads a third-party app, he gives control of the mobile in the hand of third party. And only for that reason, the OTP and MPIN was shared. So it was negligence on the part of the petitioner. Had he not downloaded the mobile app, this fraud could not have been happened. Next, Your Lords. Had the bank installed effective cybercrime system and online fraud control measure, then in that event, even if a mobile app is downloaded by a customer, money could not have been transferred from the bank account without proper authorization. My lord, we have adopted the system. MPIN and OTP is a preventive measure, and we always caution the party, don't share it with anybody. It comes in the newspaper ad, it comes in the television ad. So the finding of the court is that we have not installed, taken any security measure is not correct. OTP, it is on the record. OTP was sent to him. When he shared, the amount was transferred. If I purchase goods through this mobile app, I have to share OTP. Without that, and it is known only to the user, not a third party. So this finding is not sustainable. It is my humble submission. It is not believable that the petitioner would deliberately share his OTP, password, and MPIN so as to allow his hard-earned money to be siphoned off from the bank account by a fraudster, that too on 3 consecutive occasions in quick succession. Rather, the incident appears to be pure and simple case of cybercrime, where the fraudster had hacked the database of respondent number 3 and therefore got access to sensitive information pertaining to various customers of Louis Phillips, including the petitioner, which information was used for completing the fraudulent transactions. This is also finding of the honorable single judge that only because of this third party. So he was negligent when he has downloaded the app. He should not have downloaded the app. So to this finding is not correct. Admittedly, he has downloaded the app. Then how the bank is liable? Next paragraph 23. And then next year, sorry. Although the respondent number 2 has contended that the petitioner had shared OTP, password, and MPIN with the fraudster, yet the said claim could not be substantiated by the bank. Nothing has been stated in counter affidavit filed by the respondent number 2 to indicate as to when, how, and in what manner the OTP, MPIN, and password was shared by the petitioner with the fraudster. Your Lordship, in the writ petition itself, the petitioner has given the call journal by which OTP was shared, which I have shown earlier. So this finding is also beyond the record. The call journal was, OTP journal was submitted before the ombudsman. Ombudsman relied that journal and has given its finding that OTP was shared by the bank, and only after sharing the OTP, transaction was successful. So when the facts is admitted, it is not required to be proved. Petitioner itself has said that they have received the OTP, and it is in the record also. There is no denial. Before the Reserve Bank of India, it was submitted. In the writ petition, there is nothing that it was not there. And in fact, the petitioner himself has annexed that documents showing the call journal. So this finding is beyond the record, that OTP was not shown. Next, Your Lordship, paragraph 23. In the affidavit filed by the respondent number 2, it has been stated that on receipt of the complaint dated 19/10/2021, the bank had taken necessary action. However, there is nothing on record to substantiate the above stand of the bank. It is surprising that even after receipt of written complaint of fraudulent electronic transaction from the account of the petitioner, not even an FIR was lodged by the bank with the police. Your Lordship, the law is very much subtle. When FIR is already lodged, second FIR is not permissible. The law has been settled by the Honorable Supreme Court in AIR 2001, Supreme Court 2637. Had not be, Your Lordship. There can be no second FIR in respect of same cognizable offense, same incident or occurrence. On 18/10/2021 itself, the petitioner had lodged FIR.
Yes.
Next, Your Lordship. Then, paragraph 25 is page 140. It is no doubt correct that if a customer is negligent in handling his or her account and disclosure sensitive information such as password, OTP, MPIN, card number, etc., resulting into fraudulent transaction, the bank cannot be held liable for loss, if any, suffered by the customer. However, in such cases, negligence on the part of the customer must be cogently established by the bank by bringing reliable materials on record. What we need to prove further, when the petitioner himself has admitted that he has downloaded the third-party app, and he has shared the OTP. So when the finding of the court was that if he shares these all credentials to a third party, he has to be liable. Then
How do you know that the petitioner has shared the credentials?
Yes, my lord. As per RBI guidelines, without sharing OTP, a transaction cannot be successful. And when the transaction is successful, it is presumed that he has shared the OTP. And I have shown the call journal, log journal. It is on the record, Your Lordship.
Where is the log journal?
Your Lordship.
Log journal?
Oh, yeah. 104, Your Lordship. Page 104. 104 is the this. 105 is the main copy. Time is given. First one, destination number, then originator name, SBI, ACS, delivery status, delivered, message delivery time, 14.48.48, message, OTP for online purchase of rupees, so and so, 8 recharge payment through State Bank of India card. Each, don't share with this with anybody.
All right.
And as I have stated earlier, Google payment, we have no control. It is a third party app. Next, Your Lordship.
It just says that you sent the OTP.
Yes.
Correct.
Yes, ma'am.
So he must have received it. How do you know that he has shared it?
The time the transaction was, the time the amount was debited from the account, it is presumed that he has shared the OTP. Only after sharing the OTP, if Your Lordship, in general, when we use the ATM card, this debit card, OTP comes, and only after this filling of this OTP, the amount is transferred from our account. This is the general practice. And Reserve Bank of India has given its finding.
Yes, continue.
Next, my lord. His Lordship has quoted two judgments. It is on page 26. But this judgment is not applicable in the present case. Why it is not applicable? In this judgment, the bank has opened one account without instruction from the customer. And from the account, amount was transferred from the account. So the bank was held liable. So this is.
We'll continue it to.
Much. In the present case. In this case, what happened? An unauthorized account was opened by the bank and the amount was transferred in that account. So there was clear lapse on the part of the bank. In my case, this is not the case.
Yes.
Next judgment was referred at Para 27, page 142. In this case, what happened? After intimation of withdrawal, the amount was transferred from the bank. But in the present case, the amount was transferred before the intimation. So this case is also not applicable in the present case.
Yes.
Then paragraph 29, the most vital. Paragraph 29. In the above context, it would be pertinent to note here in that the petitioner has stated in the writ petition that the respondent number 3 has admitted that there was a breach of its customer database. If such breach of the customer's database has given access to the fraudster to the petitioner's account, then in that event, there can be no doubt about the facts that the respondent number 3 would also be liable to compensate the petitioner or the bank. It is admitted fact that there was breach of database. Then why the bank is liable? Respondent number 3, whose database was stolen, they are liable, not the bank, because there is no lapse on the part of the bank. Next line, Your Lordship. However, as noted above, the police report indicating the manner in which the fraud has been committed is not yet available, nor is there any report from the beneficiary bank indicating the manner in which the respondent number 4 had siphoned all the money from the bank to other accounts. This report is available in the record. Annexure 10 to the writ petition. It is available.
Where is that?
Yes, my lord. Sorry. And next one, 9 series.
Page.
Page 106. I have already read. In this report, the beneficiary bank has stated that the petitioner is guilty of negligence. Last paragraph. We would like to submit that the amount transferred through UPI transaction by the complainant is of high security nature. The transaction could be completed only by entering the valid UPI credentials, and the credentials are confidential and known only to the account holder. In the instant case, as informed by the complainant, though through the complainant had acted according to the direction of an unknown person, the bank regulators etc. are cautioning all customers through several platforms not to share any of the credentials of their accounts to anybody, and requesting not to click or any link, QR code, etc. Despite all these, the customers are doing all sorts of things and afterwards making complaint. Here the loss occurred to the complainant due to his gross negligence only. So the finding of the learned single judge that beneficiary bank report is not available, it is beyond the record. Report is already here. Next, your lordship. These are matters of investigation by the complainant, by the competent authority. A clear picture in these matters would emerge only when a proper investigation is carried out and the report is made available. On completion of investigation, if it is established that the fraud took place purely due to the negligence or deficiency of service on the part of the respondent number 3, then in that event, the entire liability may be on the respondent number 3. So when the finding of the learned single judge was that investigation is not complete, before that, how the bank would be liable? And it is also finding of the learned single judge that respondent number 3 would be liable after investigation. The bank deals with the public money. If bank is forced to pay the amount, then the entire banking system would collapse. Next paragraph, right? In the light of the discussion made above, it is therefore held that the online transaction that took place from the petitioner's bank account on 18/10/2021 were unauthorized and fraudulent in nature. Negligence on the part of the petitioner could not be established by the respondent number 2. Record says that he has shared the OTP, he has downloaded the third-party app. Then how there can be any finding that there was no negligence on the part of the petitioner? So my humble submission is that appellant bank deals with the public money. If this judgment is allowed to stand, the bank will suffer. Not only this amount, but in future it will be a precedent. Every person will share his credential and bank would have to pay the amount. If a person shares, why the bank should pay the amount? So on that, I have filed this appeal to set aside the order of the learned single judge and to restore the order of the ombudsman, which was set aside by this judgment.
Where's the circular of the RBI?
Yeah, my
6/7/2017.
Page 74 and relevant paragraph 76 relevant. A customer shall be liable for the loss occurring due to unauthorized transactions in the following cases. In cases where the loss is due to negligence by a customer, such as where he had shared the payment credentials, the customer will bear the entire loss until he reports the unauthorized transaction to the bank. After reporting to the bank, no amount was withdrawn.
What is clause 8?
Overall liability of the customer in third-party breaches as detailed in paragraph 6(2) and paragraph 7(2) above, where the deficiency lies neither with the bank nor with the customer, but lies elsewhere in the system, is summarized in the table 2. So here the negligence is established on the part of the petitioner. So this clause is not applicable.
Let us read. Read.
Yes, my lord. Time taken to report the fraudulent transaction from the date of receiving the communication. Within 3 working days, zero liability. Within 4 to 7 working days, the transaction value or the amount mentioned in table 1, whichever is lower, beyond 7 working days as per bank's board approved policy. The number of the working days mentioned in table 2 shall be counted as per the working schedule of the home branch of the customer, excluding the date of receiving the communication.
Nine,
Reversal timeline in zero liability, limited liability of customer. On being notified by the customer, the bank shall credit shadow reversal the amount involved in the unauthorized electronic transaction to the customer's account within 10 working days from the date of such a notification by the customer, without waiting the settlement of insurance claim, if any. Banks may also at their discretion decide to waive off any customer's liability in cases of unauthorized electronic banking transactions, even in cases of customer's negligence. The credit shall be value dated to be as of date of the unauthorized transactions.
what does it mean?
This means even a third-party transaction, even anything happened due to negligence on the part of the third party, but not on the part of the customer.
No, read it.
On being notified by the customer, the bank shall credit shadow reversal the amount involved in the unauthorized electronic transactions to the customer's account within 10 working days from the date of such notification by the customer, without waiting for settlement of insurance claim, if any. Bank may also, at their discretion, decide to waive off any customer's liability in cases of unauthorized electronic banking transaction, even in cases of customer negligence. The credit shall be value dated to be as of the date of the unauthorized transaction.
So
But
it says
here-
even in the cases of customer negligence.
Yes, my lord, but it should be unauthorized. But here the OTP was sent and only after successful transaction, the transaction was successful. This clause could have been come if an amount was withdrawn from his account without his consent. But here the act of the party is there. Admittedly, there is act of the party. He has installed a third party app. He has installed the third party app. OTP was shared. So this clause is not applicable in the present case.
Then 10,
Yes. Sir. Further, bank shall ensure that a complaint is resolved and liability of the customer, if any, established within such time as may be specified in the bank's board approved policy, but not exceeding 90 days from the date of receipt of the complaint, and the customer is compensated as per provision of paragraph 6 to 9 above. Where it is unable to resolve the complaint or determine the customer liability, if any, within 90 days, the compensation as prescribed in paragraph 6 to 9 is paid to the customer, and in case of debit card, bank account, the customer does not suffer loss of interest, and in case of credit card, the customer does not bear any additional burden of interest. So this clause is not applicable in my case. And overall, my lord, there was two mode of transaction. One was Google Pay, another was PG, payment gateway. That is through debit card. About Google Pay, the bank has no control. I have given the terms and condition of the Google Pay. It is a third party app. It is not linked with the bank. Bank is only responsible, if any, for the transaction carried out through debit card. And only when there was without OTP, any transaction was carried out. But in the present case, OTP was sent, it was shared, so bank is not liable. And Google Pay is a third party app.
Who is this order? 7/3/2022?
My lord,
Order of 7/3/2022.
7/3/20.
Page 118.
Yes. Relevant page is 119. Paragraph 2. The bank has submitted that their version dated 24/2/2022 stating the complaint pertains to the unauthorized transaction of rupees 94,204 done on 18/10/2021. The amount of rupees 64,017 was withdrawn via UPI and transferred to a federal bank beneficiary account. Amount of rupees 30,180 was withdrawn via PG transaction. OTP logs are a test for the PG transactions. The UPI transaction cannot be executed without the registered mobile number and secret MPIN. The PG transaction cannot be executed without the card details and validation of OTP. We have to submit that the transactions were executed due to the customer's negligence. As per circular number so and so, section 7(1), in case where the loss to the customer is due to negligence by the customer, such as where he has shared the payment credentials, the customer will bear the entire loss until he reports the unauthorized transaction to the bank. The query was raised with SBI and they have replied now stating the transactions were successful and authorized via OTP and MPIN. Hence, the CRM complaint was closed as successful transactions. The bank is not liable to pay any compensation as it was the customer's negligence due to which the transactions took place. The bank would have been liable to pay had there been any further monetary loss after reporting by the customer. There was no monetary loss after the customer reported to the bank. Therefore, the customer's claim is not acceptable. Hence, no deficiency could be attributed to the service of the bank under clause 10 of the Reserve Bank Integrated Ombudsman Scheme 2021.
How the customer will know before transaction would not have been a complaint. Its transaction is not done. Yes. Any more?
No.
So you are saying that so far as the GP Google Pay is concerned, you have no hand over it.
Yes, it is a third party.
And so far as the other transaction GP is concerned, what do you call?
PG transaction, that is a through debit card transaction, through debit card.
OTP was sent.
OTP was sent and it was successful. And the ombudsman has upheld that OTP was sent and the transaction was successful. So after successful transaction, bank has got no liability. Had it been paid without OTP, bank was definitely liable to pay. But since in this case, measures adopted by the bank was successful, OTP was sent. So the finding of the learned single judge that bank has not taken any measure to prevent fraud is not correct.
So you are selling the single judge
Yes, madam.
judgment.
Judgment.
On the
Because the
ground
same
that
is
the-
contradictory.
Reliance made on the two judgments is not applicable to the case in hand.
It is not applicable because I have distinguished. In the first case, the account was opened without consent of the party and amount was transferred. In the second case, the amount was transferred only after reporting of the fraud. In that case, the customer has reported fraud and after that the amount was transferred. That is not case here. Only after transfer of amount, it is evident from the FIR. If your lordship see the FIR filed by the annexure to page 66. It doesn't say that there is any lapse on the part of the bank. What is the 10? No, my lord. Annexure 3, my lord. Page 70. I'm reading the FIR. With due regard, I beg to state that I have been defrauded by a person using phone number so and so, portraying themselves to be customer care executive of Louis Philippe, in the process of giving me a refund for a blazer, which I wish to return pursuant to an online purchase. The first transaction was with one Mikesh Kumar for ₹64,017 through Google Pay, carrying UPI transaction ID so and so at 1:04 p.m. The second transaction was with free charge payment of ₹15,093 through SBI debit card bearing number so and so with transaction ID. The third transaction was also for the same amount, but I did not receive any transaction ID. And the complaint was lodged with the SBI on 19/10/2021 after 1 day, because on the very date the bank was closed. So on the day, at page 66, what complaint was lodged? With reference to the above, it is stated that I have been defrauded by a person using phone number so and so, portraying himself to be customer care executive of Louis Philippe, in the process of giving me a refund for a blazer which I wish to return pursuant to an online purchase. I had downloaded an app for as per instruction received from the fraudster. The total amount withdrawn from my account is ₹94,203.80 in 3 transactions. I therefore request you to take necessary action and help me retrieve the amount. I have lodged FIR. Already FIR was lodged by him. So the finding of the learned single judge that bank has not filed a FIR. When already an FIR was filed, the bank was not required to file second FIR. There is no complaint on the part of the petitioner that after reporting, any amount was paid. There is no complaint.
Yes.
May I please, your lordship? If your lordship permits me, I would like to place the facts as it happened. On 5/10/21, I purchased this garment from respondent number 3, Louis Philippe. I have annexed the cash memo. It is there. And I received the garment. On receipt of the garment, online. I made the payment to debit card. On receipt of the garment, I did not like the product. So I wanted to return it. So I called up the customer care executive of Louis Philippe on 18/10. And it was received by Louis Philippe. He says that he is customer care executive of Louis Philippe. I said, I want to return the product and please return my money. He said, okay, we'll collect the product and we'll refund your money. I said, fine. And it was, the situation was post-COVID. COVID had taken place in 20, and this was 21. So during post-COVID, most of the online, stores also, say for instance, this sports shop is Decathlon near the airport. If you have to buy something, you have to download that app. If you want to pay something also, you have to download that app because cash transactions were not taking place at that time. So bona fide, I believed that maybe this is also the system of Louis Philippe. So I downloaded the app. The moment I downloaded the app, these 3 transactions took place and this money was siphoned on from my account. After the 3rd transaction has taken place, I received a call from the customer care center of SBI saying that your account has been hacked. So we are blocking your debit card. And if you have downloaded any app, please uninstall that app immediately. So immediately I uninstalled that app. And this took place on 18/10/21. 18/10/21, as my learned friend has submitted, was a bank holiday. So I could not directly lodge complaint with the bank. I called up the customer care of SBI, saying that these 3 transactions had taken place. They have given me acknowledgement numbers also. I requested them to cancel that 3 transactions. They said they'd they will look into it. Then after that, on 18/10/21 itself, I lodged an FIR with the nearest police station, Jalukbari police station. Case was registered. On 19/10/21, I approached the bank, as my learned friend had shown my application. I approached the bank saying that these things have taken place. I have approached the cyber crime cell of Assam Police. Acknowledgement numbers were given. I have also approached the National Cyber Crime Bureau. Acknowledgement number was given. So please help me retrieve the amount. They did nothing, Lordship. Absolutely nothing. From time to time, I used to check the online status of my complaint. It used to show under investigation. So I waited for a reasonably long period from 19/10/21 to 25/10/22. Meanwhile, I received an online mail from Louis Philippe, respondent number 3, saying that our account was hacked. In Lordship has seen that Annexure 6. I'll point it out again. Lordship, page 83. This is a mail which I received from Louis Philippe on 16 January 22. We would like to inform you that there has been an information security incident that entailed illegal and unauthorized access to a part of our customer database. Earlier this week, we discovered that profile information of some of our customers has been released in some cyber communities. It appears that some financial data pertaining to transactions between 23rd June 21 to 1st December 21 may have been leaked. Since our records show that you have made a transaction during this period, we request you to take necessary measures to secure your credit card. So they have acknowledged, Lordship, in all fairness, that their system was hacked.
and information may have been leaked. So all this was known to the bank. The bank did not do anything, Lordship. I filed a complaint on 19/10/21. They did nothing. On expiry of the period of 90 days, I approached the banking ombudsman with a complaint that these things have happened. Please look into it. And they rejected my complaint. On the basis of RBI circular, section 7, Lordship has seen that, section 7. Page 76. A customer shall be liable, page 76, Lord, for the loss occurring due to unauthorized transactions in the following cases. In cases where the loss is due to negligence by a customer, such as whereas he had shared the payment credentials, the customer will bear the entire loss until he reports the unauthorized transaction to the bank. Any loss occurring after reporting of the unauthorized transaction shall be borne by the bank. In cases where the responsibility for the unauthorized electronic banking transaction lies neither with the bank nor with the customer, but lies elsewhere in the system, and whence there is a delay for 4 to 7 working days after receiving the communication from the bank on the part of the customer in notifying the bank of such a transaction, the part transaction liability of the customer shall be limited to the transaction value or the amount mentioned in table 1, whichever is lower. So this is it. Lordship, this is section 7. Lordship has seen section 8, the overall liability of the customer in third-party breaches, as detailed in paragraphs 6.2 and 7.2, where a deficiency lies neither with the bank nor with the customer, but lies elsewhere in the system, is summarized in table 2. So if a fraud is reported within 3 working days, there is no liability on the part of the customer. Here in this case, Lordship, the fraud took place on 18/10. On 19/10 itself, I lodged a written complaint. And on 18/10, I lodged complaints to the customer care of SBI. And my complaints were acknowledged. Acknowledged numbers are there. And I have been diligent in pursuing my complaint, Lordship. But the bank has done nothing, Lordship. It is only after I approached the ombudsman in February 22, they came up with the reply to the ombudsman saying that I had shared the OTP detail. Lordship has seen that there is gross negligence on the part of the bank, because as per clause 10, Lordship has seen that clause 10 circular. A complaint, further, bank shall ensure that a complaint is resolved and liability of the customer, if any, established within such time as may be specified in the bank's board-approved policy, but not exceeding 90 days from the date of receipt of the complaint of the customer and of the complaint, and the customer is compensated as per the provisions of paragraph 6 to 9 above. Where it is unable to resolve the complaint or determine the customer liability, if any, within 90 days, compensation as prescribed in paragraph 6 to 9 is paid to the customer. Lordship, my case is squarely covered by this, because the fraud took place on 18/10. I lodged a complaint on 19/10. The bank did absolutely nothing. It is only after when I had approached the ombudsman on 15th of February 22, they sent a reply to the ombudsman saying that I have shared the OTP. And there is no material on record to show that I have shared the OTP. The bank may have sent the OTP, but I have not received it. Just because I have downloaded the mobile phone application, that does not mean that I have been negligent. And learned single judge has recorded a finding to that effect. Lordship has seen the finding of the learned single judge. Lordship may kindly see it again. Lordship, it starts from page 137, paragraph 22. From the pleadings available on record, it is evident that the 3 online transactions from the petitioner's account took place on 18/10/21, where he had downloaded the mobile app on being prompted by the fraudster. The petitioner had done so in order to get refund of his money from Louis Philippe. The aforesaid 3 transactions were evidently unauthorized, as the petitioner never intended to transfer any amount to the respondent number 4 by downloading the mobile application. The respondent number 2 has also not denied that the transaction was unauthorized. Therefore, merely because the petitioner had downloaded the mobile app, that by itself cannot lead to the presumption of negligence on the part of the petitioner in assisting the unauthorized transaction. Had the bank installed effective cyber security system and online fraud control measures, then in that event, even if a mobile app is downloaded by a customer, money could not be transferred from the bank account without proper authorization. Regardless of whether it was a UPI or PG transaction, it is not believable that the petitioner would deliberately share his OTP, password, and MPIN so as to allow his hard-earned money to be siphoned off from the bank account by a fraudster, that too on 3 consecutive occasions in quick successions. Rather, the incident appears to be pure and simple case of cyber crime, whereby the fraudster had hacked the database of the respondent number 3 and thereafter got access to sensitive information pertaining to various customers of Louis Philippe, including the petitioner, which information was used for completing the fraudulent transactions. The participation of the petitioner appears only to the extent of downloading the mobile app. So learned single judge has recorded a clear finding that my hand is limited to only downloading the mobile application. And just because I have downloaded the mobile application, that does not lead to the irrefutable presumption that I was negligent in whatever has taken place. So therefore, the learned single judge has rightly directed the appellant bank to refund my money, because it is a clear violation of the RBI guidelines. I have shown the RBI guidelines. Clause 9 says that you resolve the complaint within 90 days. If you can't resolve, you refund the money. And they have been unable to resolve the complaint. So therefore, the single judge has directed them to refund the money. And there is no evidence to show, there is no material on record to show that I have shared the OTP. Just because I have downloaded the app, it does not lead to the irrefutable presumption that I have shared the OTP with the fraudster. And Lordship, another glaring aspect is that the transaction took place on 18/10/21. The account of the fraudster, that is a respondent number 4, the account and the fact that it is the money has gone to the account of the respondent number 4 was known to the bank from the very beginning on 18/10/21 itself, but they did nothing, Lordship. It was known to them that the money has gone to the account of the fraudster. It is apparent from my passbook transaction that the money has gone to the account of one Mukesh Kumar. And I have mentioned that in my FIR. The bank did nothing, Lordship, absolutely nothing. They just sat over my complaint. So there has been gross negligence on the part of the bank. So therefore, the learned single judge has directed the bank to refund my money. And now, Your Lordship, if I am permitted to show that, a cabinet subcommittee on banking of the Ministry of Finance, they have recommended that in case of cyber fraud, the banks should, irrespective of the liability of the customer, the bank should refund the money. Lordship, it was widely reported in the electronic media as well as in the print media.
A parliamentary panel has called for immediate compensation to cyber fraud victims by financial institutions, saying this will go a long way in demonstrating steadfast commitment to consumer protection and will push this firm to bolster their security measures. The committee strongly believes that there should be an automatic compensation system as devised by the RBI, and it should be the financial institution's sole responsibility to immediately compensate the hapless customer, pending further investigation and final traceability of funds. The Standing Committee on Finance, headed by BJP MP Jayant Sinha, had reported in its report. The report was tabled in Lok Sabha last week. Lordship, this is dated 2nd August 23. Speaking to PTI, Sinha said, we have suggested that if a customer files a complaint that they have been victim of cyber crime fraud, then they should automatically get the money back into their accounts, up to a certain limit, of course. The onus would be on the financial institutions to chase down the crime and perpetrators so that consumers get immediate justice. So that is the mood of the legislature. The legislature is aware of the fact that such kind of cyber crimes are happening rampantly. And it is the primary responsibility of the financial institutions to protect the interests of the customers. In fact, your Lordship will kindly see the RBI circular, which I have relied upon, Annexure 5. That circular itself says that it is the responsibility of the bank. May I read it, Lordship? Yes. Lordship, that apart, another gross negligence on the part of the bank is that before fastening me with the responsibility, they should have arrived at the finding that I am responsible. And that is violative of section 12 of the circular. Lordship will kindly see page 79. The burden of proving customer liability in case of unauthorized electronic banking transactions shall lie on the bank. And Lordship, in my case, the bank did absolutely nothing, Lordship, until and unless I approached the RBI with a complaint. And that also, the beneficiary bank, my money has gone to the federal bank account of the fraudster. Respondent number 4 has committed the fraud. It is very well known to the bank. They did not send even any chargeback request. And that is what the federal bank has said. Lordship will kindly see. Page 106. Money has gone to the account of the respondent number 4 in his federal bank account. And the bank knows that this is an unauthorized transaction. Is it not expected, Lordship, on the part of the bank to tell the federal bank that my customer has lodged a complaint, that the money has been illegally transferred to your customer, please refund the money? That also they have not done. Lordship will kindly see the second paragraph. We have not received any chargeback request against the above mentioned transactions from the remitter bank SBI through NPCI, that is National Payments Corporation of India, or through mail. This was the least expected of SBI, Lordship, to tell the federal bank that our customer has lodged a complaint that his money has been illegally siphoned off from his account, and it has been done by your customer, respondent number 4. The details are available with SBI. From 1810 itself, they have done nothing. Absolutely nothing, Lordship. So at times, one feels that there is an unholy alliance between the officials of the bank and the fraudsters. It leads to that kind of feeling, Lordship.
Otherwise, why will they not act? They very well know that my money has gone to the account of the respondent number 4. Money is lying in his account and they have done nothing, Lordship, until and unless they approach the RBI. And they tell the RBI that I have shared the OTP. So therefore, as per clause 7, I am responsible. What about clause 8? What about clause 9? What about clause 10, 11, 12? It is the responsibility of bank to show that I have been negligent. They fail to discharge their responsibility, Lordship. So that is why the learned single judge has directed them. There is absolutely no fault. And when your Lordship had put the question to the counsel for the appellant, where is the evidence to show that I have shared the OTP? My learned friend said it is the presumption. That presumption will not hold good. Because as a learned single judge has recorded a finding, it is not expected the petitioner will share the OTP on 3 consecutive occasions so that his hard-earned money could be siphoned off in one single day. So therefore, there is no reason on the part of this, on the part of your Lordship to interfere with the judgment of the learned single judge. The bank has been grossly negligent, Lordship. They did nothing. In spite of my repeated, I lodged a written complaint once and I visited the bank obscene number of times. They always tell me that it is under investigation, And on expiry of 90 days, I approached the ombudsman and they sent this reply to the ombudsman and the ombudsman has recorded this finding, relying on clause 7, ignoring clause 8, clause 9, clause 10. In fact, clause 8 and the learned single judge has relied on clause 8. Learned single judge has proceeded with the belief that my account has been hacked by the fraudster and my details has been collected from the database of the respondent number 3, Louis Philippe. And getting my account details, he has perpetuated the fraud. That is why your Lordship will kindly see the judgment again. Lordship, page 133, paragraph 12. It is the admitted position of fact that the petitioner was enjoying net banking facility provided by the SBI in respect of his savings account. It is not in dispute that on 18/10/21, an amount of rupees so-and-so was unauthorizedly transferred from the SBI account of the petitioner through internet banking. There is also no dispute about the fact that the 3 transactions which took place on 18/10/21 were fraudulent transactions and the petitioner never intended to transfer any amount to the fraudster. The only issue that would arise for decision of this court in this case as to whether the respondent number 2 bank would be liable to compensate the petitioner for the loss of a sum of rupees so-and-so owing to fraudulent transaction, or it is a case of negligence on the part of the petitioner. Both sides have placed heavy reliance on the standing circular of RBI dated 6/7/2017 in support of their respective claims. The petitioner has relied upon clause 9 of the RBI circular to submit that it was the bank responsibility to resolve the controversy in a time-bound manner, and having failed to do so, they would have to compensate the petitioner. The learned counsel for the respondent number 2, on the other hand, has relied upon clause 7 of the circular to submit that the incident took place due to negligence of the customer, and therefore the bank has no liability in the matter. The RBI circular dated 6/7/17 lays down certain guidelines for customer protection, limiting liability of the customers in case of unauthorized electronic banking transactions. The said circular is made applicable to all commercial banks, small finance banks, and payments banks. Clauses 7 to 9 of the circular dated 6/7/17 would be relevant for the purpose of this case, and therefore those are being reproduced herein below for ready reference. So clause 7 has been quoted. Clause 8 has been quoted. Clause 9 has been quoted, and clause 10. From a reading of the relevant provisions of the RBI circular, what can be seen is that clause 8 deals with third-party breaches, where the deficiency lies neither with the bank nor with the customer, but lies elsewhere in the system. As per clause 6.2, the liability of the customer in such cases would be zero when the customer notifies the bank within 3 working days of receiving communication from the bank regarding unauthorized transactions. Third-party breach is not a defined expression under RBI circular dated 6/7/17. Yet it appears from the plain language employed in clause 8 that in case of unauthorized electronic banking transaction occurring due to third-party breaches, that is where the deficiency lies neither with the customer or the bank, the customer liability will be zero if the fraudulent transaction is reported within 3 working days from the date on which the customer receives the communication. In the present case, even if it is assumed that the fraudulent transaction has taken to third party due to third-party breach, that is breach in the customer database of the respondent number 3, even then the fraud/unauthorized transaction was reported to the bank on 19/10/21 within 1 working day. Therefore, as per clause 8 of the RBI circular, the liability of the customer/writ petitioner in this case ought to be zero. So, Lordship, there is no reason for this honorable court to interfere with the judgment of the learned single. That is my respectful submission before your board.
Yes.
My lord, I represent the state, my lord, response number 5, crime branch. My lord, as per the, my lord, statement of the investigating officer of the crime branch, he was present before the learned single judge. My lord, the personal details of the, my lord, accused and the photograph has been identified. And as on now, what is the stage of inquiry? I cannot say, my lord, without any instructions. My lord, since there is no direction and nothing against the, my lord, state, don't have any submission until and unless your lordship, my lord, direct if required, my lord. Otherwise, my lord, it is established that the bank did not, my lord, lodge any complaint because the State Bank of India is a national bank and they have the jurisdiction and business all over India and abroad. They should have filed a complaint before the, my lord, place where the accused, my lord, committed the fraud. That has not been done. And money has been transferred to the federal bank. And they did not, my lord, immediately communicate to the federal bank to stop the transaction. Thereafter, my lord, the accused transferred the money from federal bank to the other bank. My lord, in the said circumstances, my lord, response number 3 also, my lord, they have, my lord, communicated the petitioner, appellant, that their account has been hacked, but they also did not take any initiative to, my lord, do the needful by, my lord, lodging any complaint before and the accused is, my lord, residing in the Uttar Pradesh. And we have limited jurisdiction here, my lord. If, my lord, State Bank of India has lodged any complaint before, this could have, my lord, lodged any complaint, my lord, before the, my lord, the place where the crime has been occurred. That is Mr. Mission.
Yes.
I represent response number 2, my lord, the ombudsman, my lord. On the basis of the complaint lodged by the petitioner, my lord, that the ombudsman scheme of 2021 under clause 13 of this said scheme, my lord, at page 91, the ombudsman has the power to call for the information from the bank, my lord. Subsequently, accordingly, the RBI had called for the information. They have sent the written version. Lordship has seen that finding of the ombudsman at page 118, my lord. The relevant portion of the findings at page 119, I'm repeating, my lord. 2-3 lines. My lord. Please refer to your complaint against the State Bank of India filed through the
118.
page 118, my lord, the finding of the ombudsman. My lord.
18 or 19?
18 is the starting page, my lord. 19 is the relevant page. The bank has submitted their version dated 24/2/2022, stating that the complainant pertains to unauthorized transaction of rupees so done on 18/10/2021. The amount of 64,017 was withdrawn by UPI and transferred to a federal bank beneficiary. Attached amount of rupees 30,186 was withdrawn via PG transaction, which is a payment gateway, my lord. It includes that card to dealing, my lord, cards payment. OTP logs are attached for PG transactions. The UPI transaction cannot be executed without registered mobile number and secret MPIN. The PG transaction cannot be executed without the credit card details and validation of OTP. We have to submit that the transactions were executed due to the customer's negligence. As per circular number so dated July 6 of 2017, sorry, section 7.1 that has been referred to my learned brain, my lord. In case where the loss of the customer is due negligence by the customer, such as where he has shared the payment credentials, the customer will bear the entire loss until the report to the unauthorized transaction to the bank. The query was raised by the SBI and they have replied now stating the transaction were successful and authorized via OTP and MPIN. Hence, CRM complaint was closed as successful transaction. The bank is not liable to pay any compensation as it was the customer's negligence as by invoking clause 7 of that circular. I'll come to that, my lord. Successful. The bank is not liable to pay any compensation as it was customer's negligence due to which transaction took place. The bank would have been liable to pay had there been any further monetary loss after information, my lord. After reporting the customer, there was no money loss after the customer reported to the bank. Therefore, the customer's claim is not acceptable. Hence, no deficiency could be attributed to the service of the bank under clause 10 of the Reserve Bank Integrated Ombudsman Scheme 2021. A complainant is rejected under clause 16(2) of the Reserve Bank Integrated Ombudsman Scheme. In the opinion of the Ombudsman, there is no deficiency in service. My lord, I'll come back again to the circulars July 6, 2017, my lord. Clause 7, my lord. That has been invoked by the Ombudsman. Since the transaction was by UPI and PG transaction, and that OTP must be there. That has been compromised by the customer. Then, by invoking clause 7.1, in cases where loss is due to negligence by customer, such as where he has shared the payment credential, the customer will bear the entire loss until he report the unauthorized transaction to the bank, my lord. That has been invoked by the Ombudsman. Now, my lord, the burden, my lord, lordship is page 75 of the circular, my lord, page 75, clause 4, my lord. It is to the bank to formulate some such structure for customer protection. Clause 4 of the circular, may I read? Page 75. The system and procedure in bank must be designed to make customer feel safe about carrying out electronic banking transaction. To achieve this, bank must put in place appropriate system and procedure to ensure safety and security of electronic banking transaction carried out by customers. Robust and dynamic fraud detection prevention mechanism to assess the risk, for example, gap of bank's existing system resulting from unauthorized transaction and measure the liability arising out of such events. appropriate measurement to mitigate the risks and protect themselves against the liability arising therefrom, and a system of continually and repeatedly advising customer on how to protect themselves from electronic banking payment related fraud. My lord. It is on the bank, my lord. Now, next column, my lord, it is there is alert system, SMS alert and the mail alert. In every transaction, the bank has to provide the SMS system to alert the customer. By invoking the clause 7 of this circular, my lord, the ombudsman has taken the decision that there is no negligence on the part of the bank. That is my humble challenge.
We reserve it.
I will just take to show that the account of the respondent number 4 was operational for a long period, but they did nothing. Lordship will kindly see the account of the respondent number 4.
Where is that?
Lordship. Lordship, page 109. Lordship will kindly see that my transaction took place on 18/10/21. The second transaction from the top. This is my mail ID, Lordship, a PBGHCY. Lordship, the second transaction from the top.
Yes.
They have shown that they are refunding rupees 4,000. Lordship will kindly see PBGHCY, then OK SBI, rupees 4,000.
1 minute.
Yeah, they have shown that they are refunding 4,000.
Where is it? Where is it?
Lordship, PBGHCY at the rate OK SBI 4,000, 4,000 / then again 40. They have shown they are refunding this money, and on the plea of refunding this money, they have deducted 64,017. Lordship, deposit 64,017. This is the modus operandi resorted to by the respondent number 4, which the appellant bank could have easily stopped had they wanted to in time. This was done on 18/10. And Lordship, thereafter, Lordship will see 15,000, 15,000 on 2010, an amount of rupees 15,000 has been deposited. That is my money. Lordship, again, on 21/10, an amount of 15,000 has been deposited in the account of the respondent number 4. That is my money, Lordship. And account was operational up to 28/12/21. That is apparent from page 110. Had the SBI wanted, they could have easily made a chargeback request to the federal bank saying that you please refund the money of the customer. They did not. They did nothing, Lordship. So therefore, I respectfully submit, Lordship, at the cost of repetition, that there has been gross negligence on the part of SBI in dealing with my complaint.
May I please? Annexure 9, page 106. Letter by the Federal Bank. Second paragraph. Based upon the complaint, we have taken up the matter with our support team. It is noted that one UPI transaction of rupees 64,107 initiated from the account of the Sri Pallab Bhomik with SBI on 18/10/2021 was credited in Neo Banking Jupiter Saving Bank account bearing number so and so in the name of Sri Pushpendra Kumar with our bank. The beneficiary customer has transferred the above amounts to other bank accounts via UPI accounts. Immediately he has transferred, and page 110, your lordship. What is the balance? 63 rupees, 10 rupees, and 11 rupees. page 110, which my learned friend was referring. What is the balance?
No, but on 18-10-2021, page 109. When the first amount was deposited, was credited,
Hmm.
he had a balance of 70,000.
I called up customer care on 1810 itself.
But on the next, they have a transfer date. On 19, the complaint was lodged.
No, 1810 customer care was informed.
And immediately we have stopped the transaction.
No, you stopped the transaction before that. On your own volition, you have stopped.
Yeah, yes, we have stopped after getting the complaint. We have stopped. We are bound to stop the.
But Mr.
A Parvez.
A.
Parvez.
Parvez, learned counsel for the appellant.
I feel.
Also heard Mr. Palak Bhumikar. Public respondent number 1 in person. Mr. P. Hazarika, you are for the respond number 2. For the respond number 2 and Mr.
T.K. Sharma, my
T.K. Sharma,
number 5.
learned counsel for the respond number 5. Very complete. Just one minute.
Very good.
Item 10.
What's this one?
May it please Lordship. This appeal has been preferred, my lord, against single bench judgments dated, my lord, 1/2/2021, passed in writ petition number 3549 of 2020, my lord. That there I have just placed the facts, my lord. In the writ petition, we are not made a party, my lord. And this honorable court, this decision bench has, my lord, granted leave to file this appeal. The issue relating, my lord, regarding, my lord, the petrol pump, my lord. And Messrs, my lord, MP Jalan is the petrol pump under Indian Oil Corporation Limited. Now, initially that MP Jalan and Ram Prasad, my lord, Dalmia, Messrs of MP Jalan, they have been, my lord, partners from 1/4/1989. Thereafter, my lord, the Ram Prasad has my lord, been expired, my lord, and thereafter Lakshmi Narayan became, Lakshmi Narayan was the, my lord, Mahavir Prasad Jalan. Thereafter, they'll be converted to a partnership firm, my lord, by executive partnership deed on, my lord, 4/2/1970, my lord. Now, late Mahavir Prasad Jalan partners have Lakshmi Narayan Jalan and Ishwar Prasad Jalan. These two other persons, my lord. Subsequently, that IP Jalan, my lord, has took retirement from the partnership, my lord. Now, in 1/4/2008, my lord, that Lakshmi Narayan Jalan and Rajesh Jalan has executed a partnership deed, my lord. The writ petitioner was the son of Lakshmi Narayan Jalan. And Lakshmi Narayan Jalan has, my lord, expired on 21/4/2012. Now, after his death, my lord, leaving behind these legal heirs, these are the appellants, other legal heirs, the mothers, and brothers and sister daughters. Now, once, my lord, a partner will die, Lord, as per the, my lord, section 42 of the Partnership Act, my lord, the partnership, the firm will be seized because of the death of a so-and-so. Now, what has happened, they have come up, the writ petitioner has executed a partnership deed with the mother miller. That is an appellant here, miller, is appellant number 3 miller. Appellant number 3 miller. So, that is on 23/4/2012. Now, thereafter, in papers, they were the partners, and it is going on till 2020. No books of accounts, no expenditures, no profit has been given to the mother miller. The mother miller then filed an application before the bank, concerned bank, where all this money has been debited and credited the account of the petrol pump miller, that for stop of the account. That is on 24/2020. Now, on the basis of the letter by the mother miller, that is the appellant number 3 miller, the bank has stopped miller. In between miller, in 2019 miller, the Indian Oil Corporation has come up with a policy guidelines miller for reconstitution of retail outlet, SKO dealerships, etc. Accordingly, miller, the writ petitioner has submitted proposals, miller, the proposal on 18/11/2019, miller. Thereafter, miller, before the Indian Oil Corporation, miller, and 10/7/2020, miller, the Indian Oil Corporation has rejected the proposals that on the ground that it is not in conformity of the guidelines issued by the Indian Oil Corporation for reconstitution of the dealership, miller. Now, as it has been dismissed, there's a direction to the writ petitioner that you file a fresh and proposal within 50 days, or else we do not have options. We have to stop supplying the petrol and other products. So the time frame has been given in the 15 days. In pursuance to the time frame, the writ petitioner has requested the Indian Oil Corporation to give an extended time because of some facts which has been narrated in their petition. Accordingly, miller, he on 7/8, that means after 1 month, miller, almost in a month, he filed a fresh proposal, miller. In that proposal, miller, whereby it has been shown that we are not, we have already retired from the partnership. He is the only person, miller. So accordingly, miller, 22/8/2020, the Indian Oil Corporation has stopped supplying fuel to the writ petitioner, miller, against whom, miller. So that is why they have preferred the writ petition. And in the writ petition, miller, your lordship will find what we are aggrieved with, miller. We being the legal heirs, miller. Now, your lordship will kindly, my lord, the judgment is start from, my lord, Annexure 1, that is from page 24, my lord, onwards. And the operative portion, my lord, your lordship will find 32, paragraph. Now, my lord, your lordship, just one line. 34, your lordship, the operative portion, which we are agreed, my lord. Paragraph 21, my lord. All this matter has been taken into the consideration while disposing of the writ petition, my lord. Your lordship will find paragraph 21, my lord. Page 34, my lord. What makes us came in an appellate jurisdiction, my lord? In view of the above, the present writ petition is allowed by directing, my lord, the respondent corporation to forthwith restore the supply of the fuel and all other petroleum product to the petitioner outlet. In case respondent corporation wishes to go ahead in the exercise, consider the reconstitution, the corporation is directed to take on record of the proposal submitted on 7/8/2020 for reconstitution and to take final decision strictly in accordance with the rule and giving by the opportunity to the petitioners and any other person are the stakeholders. my lord. Now, we are, my lord, agree by this, my lord, proposal for the reconstitution by the writ petitioner submitted on 7/8/2020. Thereby, they have what it has been said, my lord, that is a paragraph, that is, I have annexed, my lord. 212, my lord, your lordship may kindly. This is a 216 is the policy guidelines and 212, my lord, is annexure 23, my lord. That is at page 212, my lord. My lord will find reconstitution of proposal of existing dealership of MS MP Jalan, customer so and so, reference your office letter dated so and so, so and so. With due respect, the undersigned would like to inform you that the letter under reference dated so and so was received by the undersigned, a surviving partner of dealership. But what is a surviving partner of the dealership? That is MP Jalan Tinsukia through registered post. The undersigned tender his unconditional apology for being unable to respond to a letter under reference within the stipulated owing the pandemic situation creating by the COVID-19 virus. As you are already aware about the fact that dealership in question has been existent since the year 1967. It took some time to trace out certain vital documents to establish the legal position as on date. The undersigned, after carefully going through the contents of your letter dated so and so, has come to the understanding that the proposal for reconstitution of the dealership with the partner firm of Mr. Rajesh Jalan, the undersigned, and Mrs. Santi Devi Milan. Can you see? Whereas this, my lord, in the writ petition, my lord, so for this other partners, the mother is concerned, not a single word has been uttered by the writ petition in their amendment. My lord. Santi Devi Jalan was rejected in view of a will submitted with the proposal. At the outset, the undersigned will likely clarify that the will executed by the late so-and-so was never probated by the beneficiary, and said will not be barred by limitation, but has also lost the significance owing a flux of time, subsequent developments. The undersigned, to some extent, has understood the policy guidelines for the reconstitution of the retail outlet framed by the IOCL, and begs to submit the proposal for consonance with the same, that if additional information or documentation is required for the reconstitution of the dealership, the undersigned will furnish the same to your good self or to any other appropriate authority within the reasonable time. That in order to make the convenience for the competent authority to take decision on the reconstitution of the dealership, the undersigned begs to lay down the following facts along with the documentary support, which will be extremely vital in determining the legal position of the dealership as on date, and also verification of the proposed vis-a-vis the aforementioned policy guidelines. Now, your lordship, kindly see what it says. The dealership in question under the name and style of MP Jalan was originally allotted by the Indian Oil Corporation on 4/8/1967 to MS MP Jalan on the basis of memorandum agreement. In the said memorandum agreement dated so-and-so, Messrs. MP Jalan was defined as an individual carrying on business at Hizuguri, Tinsukia in the state of Assam, which stated herein that the original owner, Messrs. MP Jalan, was late Mohabir Prasad Jalan of Tinsukia, Assam. That on 4/12/1970, Messrs. MP Jalan was converted to a partnership firm pursuant to an execution of a partnership deed of the said proposal of the following persons. 1. Late Mohabir Prasad Jalan, late Lakshminayan Jalan, son of so-and-so, and Sri Ishwar Prasad Jalan, son of so-and-so. However, subsequently, Ishwar Prasad Jalan retired from the said partnership firm of so-and-so on 1/4/1972, and his effect and declaration was executed by the Ishwar Prasad Jalan on a judicial stamp paper in the court of Magistrate. Tinsukia was countersigned by the Magistrate that after the retirement of Ishwar Prasad Jalan from the partnership firm and Sri Ram Prasad Dalmia was inducted as a new partner, The legal position of the MP Jalan was that as a partnership firm can also be ascertained from the income tax clearance certificate issued by the Income Tax Department on the basis of the profit and loss account and the balance sheet of the firm for the year 1981 to 82 to 1987-82. The said income tax clearance certificate of the Income Tax Department establishes that fact that Messrs. MP Jalan is a partnership firm in the eye of law. Be stated herein that in the year 1989, Ram Prasad Dalmia has retired from the partnership firm of MS MP Jalan, and after submitting his retirement proposal to the firm as well as the concerned authorities of IOCL, while later dated so and so respectively. That next minute, late Mohabir Prasad Jalan during the lifetime had executed a will dated so 33/1989, and the said will was registered with the sub-registered Tinsukia Bhai number so. The paragraph 3 of the said will clearly disclose that the testator of the will, that is late Mohabir Prasad Jalan, has executed a will bequeathing of his capital balance of rupees so as on 31/3/1988, standing as a partner of partnership from Messrs. MP Jalan Tinsukia by the said will late Mohabir Prasad Jalan, bequeathed as all the rights, interests so in favor of Suresh Jalan, Ramesh Kumar Jalan, Rajesh Kumar Jalan, and Sri Sanjay Kumar Jalan, who is also an appellant here in Sanjay Jalan. The Mohabir Prasad Jalan expired in the year on 13/4/1989, and the pursuant to his date, the aforementioned will of the late Mahasilar was never probated, Milord, but the ground on which he has been taken, the will has not been probated, Milord, what he said. So before any competent court of law by the beneficiaries, by its benefit, as such, it is of utmost importance to note that the said will is no legal value as on the date or has become a barred by the application of the law of limitation. In fact, following beneficiary said will has executed a declaration on so, the court of magistrates whereby signatories to the declaration have given no objection to the brother Rajesh Kumar Jalan, so. Milord. These are the NOC which has been made in 1989, Milord, that has been given like this, Milord. In the said declaration dated so, the signatories have unequivocally declared that they are no objection in spite of their knowledge that as per the will of late Mohabir Prasad Jalan, they were entitled, became a partner of MP Jalan. And thereafter, on 689 and 29/6/19, the then surviving partner MP Jalan Lakshminarayan Jalan submitted representation before the authority of IOCL about the dates of Mohabir Prasad Jalan on 13/4/1989, and reconsidered the partnership firm by admitting Sri Rajesh Kumar Jalan as his new partner. By the said letter, it was specifically informed that although as per the will of Mohabir Prasad Jalan, all of his 4 grandsons were entitled to become the partners of MS. Malad, is very important what he said in Jalan. However, with the consent of other 3 grandsons, only the other side was inducted as a new partner. That even IOCL, while later dated, has acknowledged the fact that one of the partner, MP Jalan, has died in the April 1989. Accordingly, the process for reorganization of the dealership on the basis of the new partnership deed has been initiated. In order to facilitate the process of reconstitution, the earlier partner, Sri Ram Prasad Dalmia, has also executed an affidavit on so in the court of Magistrate Tinsukia, giving his no objection to the admission to the Rajesh Kumar Jalan as the partner of MP Jalan, Hijuguri Tinsukia. Another letter dated so was submitted by late Lakshminarayan Jalan before IOCL authorities, informing about the reconstitution of MP Jalan with the understand as the new partners of the date of the Mohabir Prasad Jalan. That the partnership deed executed between the Lakshminarayan Jalan and his son Sri Rajesh Kumar Jalan for admission of the Rajesh Kumar Jalan as the partner of MP Jalan was finally registered with the sub-registered Tinsukia by deed number so. Thereafter, the office of the Register of Farm and Societies Assam by memo number so dated so has been certified the fact that the late Lakshminarayan Jalan and the Rajesh Kumar Jalan were the partners of MP Jalan, showing the number of the farm registered so. That 8 million, your lordship kindly see what it says. The Lakshminarayan Jalan died on 21/4/2012, leaving the following person as a class 1 legal heirs, and to his effect necessary legal heir certificate is issued by the office of Srincho. Srimati Santi Devi, my lord, who is a partner of NB Jalan, also appellant herein, my lord. Ramesh Kumar Jalan. Ramesh Kumar, Suresh Jalan and Sanjay Jalan. And also Amita Goel, daughter. These are the legal heirs now before this honorable court, my lord. Are the appellant, my lord. Appellant. What I am agreed with, my lord. What is stated, because I will read the subsequent what he is saying, only I will not take so much of time. That after the date of the late Lakshminarayan Jalan, on 21/4/2000, the aforesaid legal heirs agreed and notarized deed declaring so and so, declaring that they do not want to wish to become the partner of so and so firm by virtue of inheritance to the state share of late Lakshminarayan Jalan, and shall not have any objection whatsoever if the surviving partner, Sri Rajesh Kumar Jalma, carries on business of the said business so and so, proprietor or partnership with others. That for the purpose of administrative convenience, Messrs. MP Jalan and the convenient operation of the bank account, and also maintain the tradition of the family, the deed of partnership was executed between Rajesh Kumar Jalan and Santi Devi Jalan, wife of late Lakshminarayan Jalan, on the strength of which Srimati Santi Devi Jalan is admitted as a partner of MP Jalan. However, the said partnership deed could not be registered due to the unwillingness of the Santi Devi Jalan for the same. In view of the above, the undersigned hereby submit the application for reconstitution of MP Jalan as per the policy guidelines mentioned herein above. The undersigned beg to state that if non-registration of aforesaid partnership deed executed between so and so became an impediment in the process of reconstitution of MP Jalan, which is solely because of the non-cooperation of Santi Devi Jalan, and then appropriate authority I assume may legally consider the reconstitution of MP Jalan with the clause G5, the quoted herein with Rajesh Kumar Jalan only. The Lordship kindly see what he said, Rajesh Kumar Jalan only. So that is the standard, right? So I am agreed with this. What my prayer before it is a very limited prayer. But the reconstitution has been now, the IFC has to consider the reconstitution proposal which will be submitted by the writ petitioner, the opposite party number here, OP number 2. OP number 2, Milan. So my prayer is limited, Milan. So while Indian Oil Corporation has to give an answer to my query, they have been taken into consideration our proposal also. We also will give it. So why only him? Because this the proposal which has been given by him, it is only the Rajesh Kumar Jalan. When it is a partnership farm, consists of even with the mother also. Mother has also what they said. We heard that is absolutely false, Milord. We have never executed any NOC, in favor of opposite party number 2. So till then, Milord, there should not be any supply to till the dispute between the family will be resolved, Milord. No supply, Milord, to the petrol pump, Milord. That has to reconstitution has to be done within the suppose they called us, they hear us, and let us also file our proposals. Admittedly, what he said that we are the legal heirs, first class legal heirs, and what he shows that here we have been given an NOC to them. So he'll be the sole proprietor of that MP Jalan farm. So my limited prayer before your lordship is this, that let us also do not consider this one, consider our proposals of what we are giving. And if necessary, the person here may be taken, along with all the family members, partners, the legal heirs, so and so, till the disposal of till the disposal, no of the reconstitution matter, I see maybe directed that no fuel or any particular product to be supplied to that. So that is my prayer before your lordship.
Making us party.
Secondly, your lordship will fight. We have not make a party, in the petition, and they have obtained. We're not making us a party. That is also your lordship has to consider, my lord. Why they have not picked a party? And they have stated in their proposals that we have given an NOC to that. Whether we have given NOC to that, we'll file an affidavit there also. We have not made a party. So they have proposed this court, my lord, not with clean hand, my lord. With a malified intention and by giving a false, my lord, environment, my lord, they have obtained an order, my lord. We didn't get any scope, my lord. And since 2012, my lord, the mother being also partner of this is no account has been given. That is why, my lord, it's on the record, my lord. The mother has filed an application before the submitted the application to stop stop the account of the MP Jalan, my lord. So that is my humble submission for this. Subject to, my lord, what my learned friend has said, I will get a right of reply also.
Wait, Your Lordship. My lord, what-
You are appealing for?
I'm appealing for the writ petitioners and respond number 1 and 2, my lord. So, my lord, what exactly prompted the petitioner to approach this honorable court is some other facts, my lord, not the one which has been narrated. My lord, before I proceed with the facts of the case, I would like to raise 3 preliminary objections on the maintainability of the writ appeal. Now, a projection has been made before your lordships that this is some sort of a family feud that is going on. And they are now want to become partners of the particular petrol pump, which is the respond number 1. Admittedly, there were 2 partners, which has my learned senior colleague has just now shown that there were 2 partners of the petrol pump. The petitioner number, the respond number 2, who was the writ petitioner number 2, and his late father. Now, if they want to take their participation in the legacy of their late father, then the late father expired way back in the year 2012. They were in their deep slumber up to 2019. Suddenly they wake up and they come and say that in these writ appeals that we need to be heard. This is because they know that if they go to, because the learned single judge has very rightly directed, there is no infirmity, in my respectful submission, there is no infirmity in the learned single judge's order. Learned single judge has said that whatever dispute there may remain, let them go to civil court, let them get this, their grievances redressed from the civil court. And so far as the business is concerned, since some unreasonable restriction on freedom of trade and commerce was brought into by the respondents in the writ petition, so that has been done away with, and the learned single judge directed to let the reconstitution proposal as it is may be considered, and whoever is even aggrieved by these decisions can go to the civil court. Now they knew that if they approach the civil court, their suit will be hit by limitation, because Lakshmi Narayan Jalan, as indicated here, expired way back in the year 2012. So by way of this writ appeal, now they are trying to do something indirectly which they could not have done directly. This is my first preliminary objection on the maintainability. Secondly, my lord, they have suppressed one thing. My learned friend has, senior friend has indicated the relevant portion of the order of the learned single judge, which is at paragraph 21. The same paragraph 21 was quoted in another writ petition, my lord, which they have filed seeking for compliance of this, my lord. In one, yes, lordship, if your lordship takes up one, there was a IA file, my lord, in these proceedings for my lord, craving leave for preferring the appeal, my lord. In that IA, I had filed an affidavit, my lord. IA number 732 of 2021. In the IA, there is one of my affidavit filed on 25/10/2021, my lord. Affidavit was filed by the writ petitioner. Here, lordship, if your lordship takes up Annexure 1, page 15 of the affidavit, lordship.
Annexure
1, page 15 of the affidavit, my lord. My lord, this is WPC number 1402 of 2021.
Here, Lordship, if your Lordship takes note, the parties are the appellant, my lord, himself, the Sanjay Kumar Jalan, his brother Ramesh Kumar Jalan. Now, the order, my lord, order starts from page 17, my lord. Heard Mr. So-and-so, learned counsel for the petitioners, Mr. Learned senior counsel assisted by so-and-so, learned counsel for the respondents. The petitioners herein are aggrieved due to non-taking steps by the respondent ILCL Limited for reconstitution of the firm with specific time period. Order dated 1/2/2021, which is under challenge here now. Of this court in WPC number 3549 of 2020 is still binding the parties. So in this writ petition, the relevant direction is extracted herein below. Same paragraph 21 is quoted, my lord. In view of above, the present writ petition is allowed by directing the respondent corporation to forthwith restore the supply of fuel and all other petroleum products to the petitioner's outlet. In case the respondent corporation wishes to go ahead in the exercise of consideration reconstitution, the corporation is directed to take on record the proposal submitted, because there was only one proposal, and I will come to, when I argue on facts, how this proposal has come into being, my lord. For reconstitution and taking final decisions strictly in accordance with the rules by giving opportunities to the petitioner and any other persons who are stakeholders.
Yes, my lord. That's what.
It is made clear that such consideration has been limited only towards requirement raised in the letter dated 10/7/2020, cannot embark upon deciding the legality of the partnership as such, which can only be decided by a civil court of competent jurisdiction. It is needless to say the long tenure of more than 50 years of business of the petitioner number 1, which is without any blemish, would be relevant consideration while deciding. My lord, my clients have never defaulted before the IFC. Only this particular issue, whether it has to be reconsidered. These are some technical things, my lord. For that, why the business should be stopped? Now, my lord, in this particular proceeding, it is directed that petitioner shall take steps, no extra copies. In the meantime, respondent in page 18, my lord, the last paragraph. In the meantime, respondent IOCL shall make an endeavor to act as per the direction passed in WPC number so-and-so, if possible, within next 3 weeks from today. Now they are in challenge. They have submitted that they are aggrieved by portion of paragraph 21. On one hand, they are seeking compliance of the directions. On the other hand, they are before your lordship challenging it. This cannot happen, lordship. You cannot take benefit of a particular order and again go and challenge it. And now the question is their prayer that we should also be considered whether it was done or not. Lordship, on the next page. Lordship will see page 19. Page 19, annexure 2 of my affidavit, lordship. I am just reading out, my lord. Subject: reconstitution of farm name Messrs. MP Jalan, Tinsukia, Assam. Now here, this is a notice, common notice given to all the stakeholders. The last dealership agreement was signed by late Mahabir Prasad Jalan in 1967 as an individual. Mahabir Prasad Jalan expired on 13/4/1989. Since then, there is no record of any reconstitution of the retail outlet dealership of Messrs. MP Jalan, Tinsukia. The Honorable Single Judge of the opinion, these are their internal things. Reconstitution, how do they feed it up in their system? It is their aspect. Our duty is to inform them, place the records before them, my lord, which we have done. Reference may be made to judgment WPC number so-and-so, dated, there's the previous judgment, which I have just now relied, my lord, which they have filed, and judgment dated WPC 3549, which is in challenge before your lordship today. IOCL has yet to receive any amicable reconstitution proposal from the legal years. Though white letter refers nil, signed by Santi Devi Jalan, Ramesh Kumar Jalan, Amita Goyal, Sanjay Kumar have expressed willingness to act up and cooperate for reconstitution of the retail outlet by IOCL, is yet to receive any online reconstitution proposal. Others have not submitted any reconstitution proposal. From the above communication, it appears the legal heirs are yet to settle the disputes expeditiously and apply for reconstitution proposal online. In view of the dispute, a personal hearing that has already been done. What has been prayed? Personal hearing meeting with all the legal heirs of late Mahabir Prasad Jalan is scheduled on 9/6/2021 at 11 AM for amicable reconstitution proposal with provisions of clause number G9 of prevalent reconstitution guideline for reconstitution of the commission dealership. The venue for hearing, personal hearing, will be held at Divisional Office, Tinsukia. All are requested to attend the personal hearing as per schedule.
in any case, the legal heirs does not attend partial hearing will be given at the attending legal heirs and communication on that action proposed will be taken and sent to all the legal heirs. Now the hearing was done. The annexer 3 are the minutes, my lord. Now these minutes, my lord, have been challenged in another writ proceedings, and this is under stay. So whatever relief they are claiming before your lordship today have become infructuous. First of all, they do not file a civil suit as observed. They come and say they were not necessary. In fact, my lord, if the judgment is read in whole, the famous judgment of Udit Nayan Singh Malpaharia, which relates to the law necessary party, was discussed by the honorable single judge. Then he observed that it is not a stage. What had happened actually, my lord, what prompted us to file the writ petition? On the onset of pandemic, my lord, in the year 2020, the respondent number 1 and 2, they received a notice from the IOCL saying that we have come to know that there is a will. And in terms of the will, you have to reconstitute your dealership. Now, the respondents were surprised because that will was never probated. Someone had mischievously given that information to the IOCL. So they immediately rise back to them, and it was in the pandemic time that there is no such will. Please wait, hold on for a minute. We'll give you all the details of our history. Our ancestral history will be placed before you. IOCL then what it does, it issues another letter, which I have annexed here, that they are going to give it to on holiday scheme to some third party. That was totally arbitrary. We challenged that in the petition. Then they say we'll dismantle everything. When they come up to the stage of dismantling, the honorable court intervenes, passes an interim order restraining them that no, don't touch it. Thereafter, this judgment, which is today SL before your lordship, followed, my lord. And the IOCL's reason, my lord, I have annexed that order also. On the very first day, lordship, a question was posed to them that what was the reason? Why are you restraining the oil supply to this dealership? My lord, that reason is here, my lord. They say that their computer system is not accepting the proposal of partnership. And they, in support of them, when they were asked to furnish the records, they filed an affidavit, which I have annexed here. In that affidavit, they bring on record a particular proposal format of the year 2013. Then we, in our rejoinder, we filed all the documents that see post 2013, these arrangements have been going on. So why are you restraining? Why are you putting restraint on the freedom of trade? The honorable court accepted our submissions. It was not a lease with them, my lord. We were not contesting with them in there. And there was no dishonesty on our part by not implementing because we were not bothered with them. They had long back given away their rights. 2012, the man dies, and they were sleeping, they were in their deep slumber, my lord. And today, when everything has happened, they cannot come and say that they just give us another stop the fellow. Who will be benefited? That is the actual objective, my lord. That is the objective. They want to spoil the business. By stopping the supply, this 50-year-old dealership will die, my lord. This is my second objection. Third objection, if you at all project a picture of family dispute, why haven't you, this is a proportional family, my lord, Hindu undivided family. Why haven't you implemented the Karta? Karta's name, your lordship will find in the legal air certificate, everybody is there. Suresh Jalan, he has not been with a party here. Because Karta will come and file an affidavit and give the clear picture before the honorable court. Very tactfully, they have restrained from implementing the Karta. This I have taken objection in my affidavit in that fellow gravely petition. So these are three primary objections which I am taking. If your lordship wishes to hear the matter on merit, I am likely to argue that off. But today, lordship, I think 10 minutes.
No, it's being hard on merit.
Final hearing, Lord.
What is the argument here?
Because
He has argued on merits.
Yes.
my lord, there are other things. Why we have to come here and why I have, because I have to defend the judgment of the honorable single judge, my lord. That is why I have to go on.
Given your preliminary objections that we have recorded.
Lordship.
Now you can proceed on the merits.
Yes, lordship. Then, my lord. But I will take some time, my lord. 10 minutes. If your lordship wishes, I can go ahead. I just indicated, my lord.
Huh? So I don't think I will take. Sit for 15 minutes. This single bench so.
No, but I have not concluded.
No. That he wants to make some submission. Let us hear what he has to say.
My lord, the Indian Oil Corporation has given dealership to one party. Partners have died. It has to be reconstituted according to the guidelines. Now, many issues have been brought in that there is a will, that the will has not been probated, that the account of the firm was said to be stopped. There is a civil suit, everything. Indian Oil Corporation, which has given the dealership, is not concerned with all that. Indian Oil Corporation wants the, my lord, the legal heirs of the deceased partners of the firm to place the documents for reconstitution of the firm. And the basic requirement is that all the legal heirs, they have to, my lord, in whomsoever's name the my lord dealership has to come, the others have to give the no objection. That having not been done, we rejected their application for reconstitution. Then they came before the court. And eventually the order your lordship has seen. What this honorable court in the earlier, in the writ petition has said, that you reconstitute it by considering one particular application, the latest application that was filed. In the meantime, my lord, there has been, my lord, the IOC tried to bring all the, my lord, legal heirs so that they settle their disputes and come to a solution. There have been many sittings. Mind you, sir, are there on record. Ultimately, my lord, they could not come to any my lord, solution. Therefore, we didn't have any of my lord, any other option but to reject their claim for reconstitution. Then, my lord, there is a provision, my lord, in the guidelines that if there is family dispute amongst the legal heirs, if they cannot settle it, the IOC will give them time, reasonable time. That we give you 6 months time to resolve the dispute. If you can resolve the dispute, and you tell us to whom this is to be reconstituted, then we'll reconstitute. If you cannot, we'll give 2 years time. Up to 2 years time we will give. But after 6 months, you will not be running it. Because if you cannot settle for 6 months, then we'll run it by making some other arrangements. And within 2 years, if you can settle down, then you'll get it. Now, my lord, that notice was issued. And challenging that order, that notice, the writ petition number 7316 of 2021 has been filed. And there is a stay order. In that, my lord, application, my learned friend's client, my lord, filed an application for vacating the stay. Because, my lord, after the issue is reconstitution only, we need not go into all the details. What is your dispute? We only want to know that these are the persons in whose favor this is to be reconstituted. Now, when the, my lord, application for vacating that interim order in the writ petition is filed, then the submission is made by my learned friend that there is a writ appeal pending. Now, before your lordship, my lord, the submission is made that, my lord, that writ petition is pending and there is a stay order. As a result, my lord, nothing happens in both the, my lord, courts. Therefore, my submission will be, my lord, the honorable single judge has directed that you decide the reconstitution proposal. Your lordship will fix a time limit, directing IOC to consider the last the application for reconstitution and pass a reasonable order and abide by the guidelines.
Yes.
That will, my lord, resolve the issue. Otherwise, my lord, in the writ petition, they will say writ appeal is pending. In the writ appeal, they will say there is a stay order in the writ petition and the matter is hanging, my lord. They have to resolve their dispute. So, my lord, we'll pass an order on the last application of the of reconstitution, which has been directed by the honorable single judge. And then we'll go according to the guidelines. If they can satisfy us that they have resolved the dispute and it has to be reconstituted, we'll do it. Because, my lord, IOC is basically, my lord, a business enterprise. We do not want it to be closed, but at the same time,
when some legal errors raise some objection, we have to go by the, my lord, guidelines. So that is my humble submission, my lord. Your lordship need not go into all these other aspects about, my lord, who has died, who has given an affidavit, who has filed a suit, what is the will, whether the will has been probated. These are not the issues before your lordship, in my humble submission. So, my lord, I'll implore your lordship that your lordship will direct the IOC to go ahead with the reconstitution process in accordance with the guidelines, and your lordship will fix a time limit for us, so that we are also bound by that. This is my humble submission, my.
Pursuant to the, you know, let's see, was a hearing is was minors, and it's stated by, is it pursuant to the, you know, single?
Yes, so basically,
this,
just, I'm sorry.
This IA, I mean, the page 21 minutes in IA.
Yes, my lord.
Is it pursuant to the order of this, appeal order of a single judge?
My lord, that has been reflected in the my notes itself, my lord. In fact, after the my lord single judge's order, my.
As per para 21, impugn judgment in the appeal.
My lord.
So this has been stayed.
Well,
No, my lord. That has not been stated.
He said.
The single judge's judgment.
No, no.
In another report.
The minutes which he has referred in IA,
Yes,
is it in pursuant to the order of the London single judge?
my lord, that order, my lord, against which that particular writ petition number 7316
Yes.
has been filed. My lord, that your lordship will file in the, my lord, affidavit in reply of the appellant against the, my lord, IA. In the IA, the appellant has filed an affidavit in reply.
2016. Page 23.
Page 23 of the, my lord, IA is the, my lord, minus of the meeting, but your lordship wanted to know what is the order by against which they have filed the WPC 7316 of 2021. That order is dated, my lord, 16/12/2021. Your lordship will find that in the, my lord, affidavit in reply filed by the appellants.
in the appeal.
In the IA.
IA.
In the IA. Yeah, IA number 732 of 2020.
Page.
Page 21.
21 is the minutes.
There's an affidavit, my lord, filed by,
In reply.
sworn by Sanjay Kumar Jalan. Yes, my lord. Affidavit in reply to the, my lord, IA.
I leave petition. Leave it, take it.
No. IA in affidavit in reply. तुम्हें file करता तुम्हें ना रहा. Page 21.
Yes.
May I read that order? You lost the, my lord, the picture will be clear. Subject, operation of retail outlet, Messrs. Mahabir Prasad Jalan, Tinsukia, Assam. Sir, reference may be made to the minutes of the meeting held at Tinsukia Divisional Office, Sripuria Road, so-and-so. After date of MP Jalan in the year 1989, proprietor of the subject Aro dealership reconstitution of the retail outlet is pending since then. As we understand that there is a family dispute among the legal heirs of late Mahabir Prasad Jalan, so the legal heirs have not been able to proceed with the reconstitution process jointly. So the legal heirs of Mahabir Prasad Jalan were invited for a personal hearing at Tinsukia Divisional Office on 9/6/2021 for an amicable solution to the reconstitution issue. However, the meeting ended without any logical conclusion to the reconstitution issue, and accordingly all legal heirs present in the meeting were requested to resolve the dispute and arrive at a mutual consensus for the dealership reconstitution within 6 months period with effect from 9/6/2021. Further, it was conveyed to all the parties present that in case dispute not resolved within the stipulated 6 months period, necessary process of taking over the retail outlet by IOC on holiday scheme would be initiated. Consequent to the meeting held on 9/6/2021, till date, after completion of 6 months period, we have not received communication from any of the legal heirs of late Mahabir Prasad Jalan on reconstitution of the RO dealership. Since no resolution of the dispute among the legal heirs of the late Mahabir Prasad Jalan has taken place till date, the corporation has no option but to proceed for operation of the retail outlet under the corporation's holiday scheme. This is as per provision of clause G9 of Ministry of Petroleum and Natural Gas Reconstitution Guideline dated 4/6/2018, reconstitution of commissioned dealership. Now, this order has been challenged by my lord, the writ petitioner, respondent number 1 and 2 herein. In my lord, WPC 7316 of 2021, and the honorable single judge in that case has granted an interim stay
Where was
on.
that?
Huh? In fact, my lord, your lordship will in the next page 22, your lordship will know the my lord holiday scheme. Then my lord, page 23 is the order passed in 7316 of 2021. Order dated 28/12/2021. Heard Mr. So-and-so, the grievance of the petitioner is putting the retail outlet under holiday scheme. Such decision was communicated to the petitioner by communication dated 16/12/2021 that your lordship has just read. Now, my lord, the operative parties, last one sentence, taking note of the earlier decision of this court as well as the fact that the petitioner is still running the petrol pump as an interim measure, the decision to put the petitioner on holiday list is stayed till the returnable date. The respondents are at liberty to file application for modification and vacation of the present interim order if so advised. Then, my lord.
Beyond this minutes, you have got a step further.
Yes, my.
That decision has been stayed. They have challenged the decision.
They have challenged the decision and there is a stay, therefore we cannot do anything. And the matter of submission.
In the minutes, there was you tried to come to a agreement.
Yes.
That was not possible.
Yes.
You gave them 6 months.
Yes, my.
6 months, nothing happened.
Nothing
Therefore,
happened.
you passed the order.
Yes.
Saying that you're putting under holiday scheme.
Holiday scheme. But that has been challenged and there is a stay. And my lord, when they have filed an application for vacating the stay, they say the this retail is pending.
That is what creating trouble, Miller. In the writ petition, Miller, single man, they said that there is a pending, the retail is.
Right.
There is a minor. This decision. Direction. By having the minutes. That is in compliance. Compliance to the thing.
You can take up a single bench matter. So we'll raise. What will give it parted or can I take it up tomorrow? We'll take it up tomorrow. Because this bench is sitting only for 2 days.
Yes, fine.
So if you keep it parted, then it'll be a big issue.
My lord, this order has been passed after the judgment of the honorable single judge who is directed to go ahead with the
That's correct.
reconstitution.
That's correct. That we have taken note of.
Because the judgment is dated 1st of February 2021 and this order was passed 16/12/2021. Before that 6 month time has already, my lord, a notice was given that you will resolve within 6 months. They didn't do it. They could not do it rather.
In fact, IOC also handicapped because of the orders which has been passed with the single ban. Now, when the retail bill, there will not say that when we file an application for vacation of the stay, Miller, they say.
What happens if we pass an order in the line that the IOC has passed? asking you to have a,
Definitely, my lord, IOC, my lord,
asking both the parties
yes,
to come to an agreement for reconstitution. Then approach the IOC, we give you some fixed time.
my lord.
And after you agree with the reconstitution, approach the IOC and IOC will take its own course of action.
If they cannot come to a, my lord,
Sir,
they
they
cannot
will-
resolve it, my lord, we have to go by the guidelines and
Guidelines.
give them 6 months time to, my lord, resolve the dispute or how.
Can you resolve your disputes? Huh?
When the even the pendency of the opportunity was given to impose the mediator, I could give them talking the mediator. That also didn't materialize.
That has also failed.
Meetings were held, my.
So all of you are so hellbent.
So another writ petition is pending, where the IOC's order has been stayed. Writ appeal is also pending, where you are challenging the earlier order passed by the learned single judge, which provided for reconstitution only. On the basis of the judgment, you had the meeting.
Yes, my lord.
The reconstitution proposal also has certain clauses. If there is a specific clause, this has to be harmoniously construed in my understanding. It also says that if there is if some of the owners are unwilling to come forward into the partnership, then the existing partner can be allowed to continue with the business. What my respectful submission is that stopping the business of the partnership will do no good.
No, at this stage, we're not going for stopping, my lord. I am not submitting on that. What I say is that, my lord,
The honorable single judge in the judgment has stated don't put it on holidays. Our cause of action for going for the second round of litigation was that it was specifically stated that we are putting it on the holiday scheme. Whereas the honorable single judge has specifically held that no, it is such a
not
wrong
held,
business.
that is an interim order.
No, in the judgment it is written. In the judgment, it is decided that it is holiday scheme because holiday scheme later we get placed before a single judge in the first round of litigation. And the Planet Court expressed this displeasure on the holidays because holiday scheme means it goes to some third party. The this original owners only get few some petty money for the.
My lord,
You resolve.
no, my lord, I'll just a point out, but whether, my lord, lordship can you see whether he.
Mother was inducted as a partner. She was there. She, as my learned senior colleague has submitted, she wrote some complaints to the SBI, who is the banker, my lord. Then we came, then litigations ensued. We came before this honorable court in a civil revision. I have annexed that order. Honorable court said, okay, you give her all the transaction details.
That has no connection.
And if you are.
That has no connection. That has no connection with the recovery.
As on this.
Either the matter has no connection with the present
That is the
application.
problem, my lord.
Field, my lord.
That is the problem, my lord.
That another things which I pointed out, my lord. In fact, this honorable court has referred the matter for mediation. He refused, my lord.
No, my lord, we participated.
18/5/2022, there's a my lord, orders. Your lordship will kindly go through the order of 18/5/2022. Refer to the mediator. And he refused
What
to
has
give.
happened, my lord, if I am to apprise your lordship on the mediation, my lord, what happened? The petitioner number 2, who was holding 50% stakes in the partnership, his share was brought down to, my lord, 12% or something like that. Because if you want to step into the legacy, you can step into the legacy of late Lakshmi Narayan Jalan, the partner who has expired. While doing so, you cannot encroach upon the share of the living partner. And when these aspects were brought to the before the learned single judge, learned single rightly directed, you go to a civil court. Because if you want to sue for the money, because in a partnership, it is for the there can be a claim for money that this much of amount of money is deprived of me. That claim can on any day lie before them. We are ready to share the audited accounts to them. You can think over it. We'll take up tomorrow.
My lord.
You can think over it. You can talk to your clients also.
Yes,
I think that is the best solution
Yes.
that
Yes.
Mr. MK Chowdhury, whatever he has proposed. I think that is the best solution. This court also accepts the, so that we can have a
Tonight you can have a talk.
We are not now. IOC is not taking sides, my lord.
Yes.
It has to go by
But
the.
Mr. B. Boral and standing senior counsel assisted by
Yes,
S. Islam and counsel for the petition appellant. Also heard Mr. G. Rahul learned counsel appearing for the responder number
1 and
2.
1 and 2. And Mr. M. K. Chowdhury, learned senior counsel assisted by Mr.
P. Bharatwaj.
T. Bharajwas for the respond number 3.
3 to 6.
3 to 6. Shall it be quartet? No,
My
it
lord.
will be dangerous.
Let us, my lord, try tomorrow.
Yeah, we'll just do it like this, list the matter again on, give tomorrow's date.
How that?
Oblige.
Me, please, as well.
Yes.
My lord, item 17, my lord, sir, listed today, my lord. My lord, the matter pertains to, my lord, admission of first year medical, my lord, UG, my lord. My lord, here my time is of essence, my lord. Pretty important because the appellant has been illegally deprived of the medical seat, my lord. My lord, I understand, my lord, today it may not be possible. My lord, if my lord, they kindly take it up tomorrow, my lord. Maybe at 2 o'clock, my lord, because here there are guidelines by the Supreme Court that it has to be done within a time frame, my lord. That is the reason, my lord.
But the time frame is by my lord 30.
And in fact, my lord,
September.
the eligibility.
This matter was called up. But
My lord, I understand. I was on legs. My deepest apologies, my lord. In fact, my lords don't have to go on the eligibility part, my lords, whether I'm eligible, because that has already been decided by the honorable chief sitting in the division bench, my lords. 3 days back, I have appended the orders. In fact, there was a general stay order passed, my lords, and the stay order was flouted by the respondent authorities, and it was not. That is why I'm before your lordships, my lord. So insofar as the eligibility is concerned,
Seats are filled up, my lord.
my lords, I'll address your lordship. What is the way out, my lords? I'll address your lordships. If your lordships kindly take up the matter tomorrow, my lords. Kindly, my lord. Maybe at 2 o'clock, my lords. Kindly.
Oh, I think the cost list is already out, except
I
the.
I won't take much time because.
How about Monday?
My lords, because time is running out, my lords. Otherwise, I wouldn't have requested, my lords.
No, otherwise, my lord, 30th September is the last date as per
My lord,
the Supreme Court's order. There cannot be any further admission thereafter.
My lord, that is
I've
wrong,
read
my
that.
lords. I'll address your lordships on that. I'll address your lordships. I'll satisfy.
My lord, tomorrow.
Yes, tomorrow.
My lords, another request, my lords, since it's a miscellaneous day tomorrow, my lords. Look, can it be fixed at 2 o'clock? Otherwise, the matter may not reach. It will come in the orders column, my lord.
2 p.m.
2 p.m. I'm very grateful, my lords. I'm deeply obliged.
Well, I beg to mention item number 14, 15. Well, this appellant will repair, my lord, and there is some urgency also. It's possible next week, my lord, before Puja vacation. And my lord.
Yeah, for the appellant.
Yes, the respondent rubber boots and
On request made by Mr.
MJ Borwa.
M.J. Barua, learned counsel for the appellants. List the matter again on, list the matter on. When?
Next week, my lord, they are hearing the
12th.
Obliged.
Give you a date.
11th of
11th, my lord, that is.
Due to paucity of time, this case could not be taken up today. Accordingly, list the matter on. 11th is a Wednesday. You want it on a?
11th is, anyways, it's a part-heard matter. So after the motions, automatically it will be called out.
11th or 12th? Which one you prefer?
12, my lord, I have some difficulty on 12.
11th.
Interim protection pass.
Interim order pass only to continue till the next.
3 order.
Obliged, deeply obliged.
My lord, myself, I may behalf of Amita Story.
B. Bhuya, my lord.
B. Bhuya.
She's for representing her.
Okay. No, I've not recorded anybody's name.
Not
3.
None appears for the review petitioner. You say that none appears for the parties. List after 2 weeks.
No,